kindly. Yesterday, application was disclosed in MFA disclosure matter. I have filed application for withdrawal of the amount. That application says the amount without any order, the judgment either transferring or permission to withdraw me. The amount has been transferred by the judicial.
So all right. Now amount is before the claims tribunal.
That amount I cannot withdraw unless there is an order by this honorable court. Yesterday I met the Mahesh. He said it is not so. I cannot adjust that amount. You withdraw your amount. I will pay the amount. I will pay the amount and recover it from you. You is transport operator. Otherwise, there will be a clash between the insurance company and the owner. That is what Mahesh said.
No, it is not like that. No, it is not like that. The amount is already transmitted now. So all right.
Unless there is an order for permission to withdraw by this honorable court, the MSCT will not permit me to withdraw. That is what Mahesh said. Otherwise,
you file an application there. How the MSCT can withhold that amount?
Unless there is an order by this honorable.
How do you say that? See, this appeal, the amount is statutory deposit.
There is no specific order.
See, this is only a statutory deposit.
Yes.
Once the appeal is disposed of, the appeal amount is released.
No order is passed to the judgment, either withdrawing or for transfer of the amount.
All right. Go ahead.
Mahesh only informed me. At the time of recovery, I cannot recover you from the amount. You will say, if you minus 50,000, you will pay. I cannot accept it. I have paid the full amount to the claimants. That is, you will get it from the MSCT and paid it to the claimants or to the insurance company. That is what the
But this respective amount.
he will come and say that he has no objection. Otherwise, at the time of
All right. All right.
Either I have no objection. I have no objection even to pay the amount to the claimants. Yeah, one of the order must be there. That is what.
My lord, serial number 35, my lords. I appear for the appellant, my lords. There is a possibility of settlement in this matter.
There is a possibility of settlement. This matter after 2 weeks.
Much obligation.
Serial number 37, your lordship.
37 only.
35. This is 2011 matter. Why? 2011 matter is not no adjournment. Huh? Sorry? Why? See, 2011 matter still pending for admission. It's your appeal. You don't want your appeal to be admitted. Then argue the matter. What is the difficulty? If there is genuine difficulty, I can grant adjournment. Not for this, I'm here for asking. So what is your genuine difficulty? Sorry? Senior is not in station today. Not in station. The request of Honorable Counsel for the appellant. This matter on Tuesday.
Serial number 4, my lord. My lord, serial number 4.
Wait. At the request of for the appellant. Respondent. This is 10th December. 7th December.
Serial number
959 of 2014. Respondent died again.
Respondent died, huh?
Respondent died.
37.
If I may make one submission also.
Respondent.
Only one respondent.
There are 2 respondents.
First respondent is Guru Mallappa is died.
And also for the first respondent would submit that the first respondent has died on which date?
Death certificate.
Appellant to verify and take necessary steps.
Your Lordship, I am for the appellants, serial number 37.
Yes.
Uh,
First
Your
respondent
Lordship,
is dead.
respondent.
Take
Your
steps.
Lordship, I'll take instructions, Your Lordship. SR Anuradha is appearing. She's designated as senior counsel. I've asked the bank to give me fresh wakalat. 2
That is
weeks.
between you and your client. Now, anyway, the matter is adjourned now. First
Yes.
respondent is reported to be dead. You
Yes,
take
sir.
steps.
Yes,
Then file wakalat also.
much okay.
Let us pray for 1 week accommodation. I'll comply with all the subjects.
2009 matter.
Some difficulty.
When this objection was raised.
Each time, my lord.
Why we extend to pay the process fee in 2009 matter?
Some difficulty with communication with the client. I will
To pay the
ensure
process
it's paid in 1 week.
process fee.
I will ensure it's
Your
paid.
client will come here and pay the process fee, or your clerk will pay the process fee. 3 days time granted to pay the process fee. Registry to issue notice.
Probate was granted to me on 11th December 2020. There were 2 petitioners.
Hmm.
In terms of the probate, I had to furnish an administrative bond.
Hmm.
6 months later, my lord, second petitioner passed away. I brought it to the notice of the registry.
Hmm.
Despite that, they're insisting that I furnish administrative bond in compliance with the order, or else seek modification of the order.
The probate is granted in favor of whom?
In favor of 2 petitioners, my lord, son and mother.
Hmm.
Mother has passed away since.
Hmm.
I already filed my accounts and inventory. Therefore, now, since the mother is no more, there's no question of her filing an administration bond.
What about the first petitioner?
That is the office note that is raised. I am willing to file for the first petitioner. They are insisting that either I file for both if possible, or that I seek modification of the order.
Did you file for the first petitioner? Did you file the bond for the first petitioner?
They are not accepting the bond. That
You first file it.
they are not accepting the draft. They're not even approved. If my
How
lord
did-
can pass an order,
Have you reported the death?
I have reported the death.
Where?
But
When?
I have reported the death to the registry, and I've even filed an application on their instructions.
When?
My IA, my lord, on 23/11 came up with the bench that had passed the order of probate. The bench said there is no question of modifying the order and asked me to say that I'm not pressing the IA. My honor, my lord, please 23/11/2021, along with that, there's an annex job.
The Learned Judge says, liberty is given to the party to take recourse to such remedies as available under law. What do you understand by that?
I filed an application to modify. The learned bench said at that point, there is no question of modifying an already granted order. If one person is deceased, you file for the other person. But my difficulty is registry. I have taken so long to come to this step to even get them to put an office note. If my lord can at least pass an order, say, directing me to furnish and them to receive it, I will gladly do it within 1 week.
Where is the order?
11/11/2020. 11/12/2020.
In terms of order dated 11th December 2020, this court has granted the probate in respect of will alleged to have been executed by K. Shivraj. Will executed by K. Shivraj on 25/4/1992. Stop subject to the condition that the petitioners have to execute administration bond. Stop. Subsequent to this order, the petition number 2 died
26/9/2020.
on 26/9/2021.
2021.
The death of petition number 2 is brought to the notice of the court. There are no other errors. The petition number 2.
No.
Are you sure?
Yes,
I will state it so.
but ultimately, petitioner, respondent number 1 and petition number 1 are the sons of petition number 2.
No. Petition number 2. You mean to say she died intestate?
She also has a will, my lord, but that is not the question today. We are probating a will of another
No,
party.
that is understood. No, she has acquired some right under the will executed by K.
The
Shivraj.
will, if my lords want to see the will says I am appointing two executors. In the event one deceases, the other person will act as sole executor. It clearly stated so.
Who is the beneficiary?
Beneficiary is petition number one. Petition number two had a living right in the house.
That's all.
That's all.
That one. And learned advocate for the petitioner would submit, first petitioner would submit that since second petitioner is dead, the second petitioner is not in a position to execute the administration bond as ordered in the order dated 11th December 2018. Under the circumstances, taking note of the death of petition number 2, this court directs the registry to accept the administration bond to be executed by petition number 1. What about accounts?
Accounts and inventory have already filed. Now there also I filed only from petition number 1.
Registry to pick up the matter as soon as the administration bond is executed. There are so many impeding applications.
Orders will pass and respondents were made as a party. But now the application was at the time of respondents chief examination, this application for order 8 minutes is filed. But I need time to file my objections.
Which application is filed under order 8?
2 of 2022.
2 of?
2022.
Permission to produce documents.
10 years back they were impeded and they had already filed objections.
Which documents they want to produce?
They have already they're now producing 27 documents.
What are those documents?
Yes, sir. They have not explained what are the documents and why is the delay in producing those documents. Hence, means I have to file objections.
What are those documents?
But sir, the certified copy of the proceedings and the marriage certificate of the previous families, all those documents, I need to go to take instructions, file my objections. Because now they are filing this, they are converting this.
Why the document should not be, production of document should not be allowed? Don't stand on technicalities. Let them produce a document. You want to cross-examine on those documents, you cross-examine.
My prayer, quite expensive.
Now, will is disputed. Will is disputed. Now, it is converted into suit. Why?
It has to be converted into probate to EOS. She has not yet.
Why? Why? Then without conversion, how the proceedings can go further? So if it is objected, then what is the position? Section 295. 295. You should submit about this in the first instance. You again wanted to take some time to file objection and all. So if it is converted into suit, then you can produce the documents. You will have no objection. You will have no opportunity to file objection then.
Now at a later stage they are filing.
All right. Now where is the statement of objection? Who are opposing the bill? Where is the objection? So any application for impeding the party is pending? No application is pending. I number 2 of 18 is 2 of 18 still pending or what? At the request of Learned Counsel for the petitioner, this matter on next Friday.
Please. And find my objections.
No, not for our filing objection. To find out as to how many applications are still pending. Then there is no point in filing objection when the will is disputed. It has to be converted into suit. This court can't proceed further. Simple as this. Just tell me how many applications are still pending, impeding application.
Is it one? 24th is a matter before the registrar. 28th is a matter before the registrar.
For that it will come.
I appear for the petitioner, my lord. In this matter, the bond has been submitted to the registry, but witnesses were not able to come on this date. And after the pandemic, I was not able to contact the petitioner, my lord. Kindly have 4 weeks time. I will see that the bond is executed.
First of all, for the petitioner. 4 weeks time granted to be needed.
Much obliged, my lord.
Four weeks time granted.
Respondent was required to file objection far back as in February of this year. It has been filed.
You want to orally object or what? You have no objection to grant probate. This old matter. Are you really seriously disputing the will? Who are you? How you are related to the testator?
It's a matter between 4 children of the deceased of parents. A brother and a sister died successively, therefore there are 2 petitions here. This is one brother who has a claim against the deceased. They are trying to settle it, but doesn't seem to be forthcoming with anything.
He would be beneficiary in the absence of will.
Being a beneficiary is not.
No, he would succeed in the absence of will. Would he succeed in the absence of will?
There is no will.
You are not seeking probate?
No, I'm seeking letters of admission.
Letters of admission.
His part of his claim, entitlements have been paid to him.
Then
And he can't have any objection if he has a claim against the deceased.
2021 matter. Not yet filed objection. The request of learned comes for the respondent. 2 weeks time granted. Finally.
Good matter.
Yes.
The succession certificate, the party died interstate 2014. So the office of section raised this for expectation of the notice of the deputy commissioner. But in this case, that doesn't arise because there are no immovable properties. Only one bank account and 2 fixed deposits. So that I have done the equal by saying that
Petition by whom?
by the legal as my lord. That is one sister and nephew with a niece. But she was a spinster. So her sister, class 1 has her sister and
Evidence is to be recorded.
not in this case.
Why?
But they're all the legal as are brought in record.
Only for that purpose. Inquiry. That's what inquiry is conducted.
Paper copy case, that I filed in I number 2. That may be also.
Citation not yet published.
First year.
Application is filed. Which is that IA?
I number 2. I number 1 may be withdrawn as not present.
What is I number 1?
Or notice to the deputy commissioner, but here there's no immovable property.
I number 1 of 2022. Is not pressed by the learned counsel for the petitioner. Accordingly, same is dismissed as not pressed. I number 2 of 2022 is for publication of citation. Which newspaper?
So in the Hindu Bangalore edition and Udayavani Kannada edition. Bangalore.
For the reasons assigned, I number 2 of 22 is allowed. The citation is to be published in the newspapers mentioned in the application. Justice matter after publication. Date after.
Published on
The citation to be published on or before. Fixing date of appearance as.
Appearing for the appellant, Your Honor, I pray for weak accommodation to take steps, Your Honor.
Why? What is the matter?
Your Honor, my senior is out of station, Your Honor.
It's a 2019 matter, review petition.
Yes, Your Honor.
Submit on merit first. What is the error apparent on the face of the record?
Your Honor, I'm not aware with the facts of the case. So my senior is just to argue, Your Honor. He is currently out of town, Your Honor. Just Monday, if it might be taken, Your Honor, my senior will come and argue the matter in the court itself, Your Honor.
At the request of learned counsel for the petitioner, list this matter on Monday.
Much obliged, Your Honor.
For the appellants in this.
Yes. Why? No, your appeal was dismissed on 12/12/2007. No, you are not sent the copy. The request of learned counsel for the appellant, a week's time granted to remove the office objections. List this matter on. I will fix a date. If it is not done again, it will be dismissed. List this matter on 24th November.
11, Rishi Bhushan.
Paper book already filed, but at 14 once to 19 filed.
19. Learned counsel for the appellant submits that the paper book is filed on 14/1/2019. Registry to verify and put up. The letter. Paper book accepted.
Last time it is not there and.
Sorry?
Poverty they are there.
How much cost is imposed?
The cost is 500 rupees for delay in 1 week. 2 months is delay from.
Since paper book is filed, the cost imposed is waived. This is matter for final hearing.
12, Markesh Susper.
Mostly in this case.
Sorry? I am appearing in this matter.
Maybe not.
How?
Gulf is not there in the file.
This is from which court? Registry to read the name of Anant Ramnath in the court list.
Given NOC, not.
Sorry?
Given NOC. This case, still not.
You have given NOC to whom? Client. Where is the acknowledgement?
Issue notice included.
Learned counsel for the appellant would submit that you would issue notice to the appellant and would retire from the brief. 3 weeks time granted to.
13, validity. 13.
2 weeks time granted to file the paper.
14, Srinivas.
Millard, serial number 13, I'm sorry, Millard.
2 weeks time granted.
ಅಲ್ಲ 4 weeks ಕೊಡಿ ಸಮ್ ಯಾಕಂದ್ರೆ ಸ್ವಲ್ಪ
2011 met.
I understand Millard. Connected ಹಾಕಿದ್ರೆ it may not be necessary also Millard. I will
4
file
weeks,
Millard.
4 weeks time.
Oblige.
14,
For final hearing.
Learned counsel for the appellant and respondent would submit that the paper book may be dispensed. Request is granted. Paper book is dispensed. This is matter for final hearing.
15,
For what? Now, what are the office objections? Office objection on the process memo. Deficit. Yes. Learned counsel for the appellant would submit that the needful will be done in 2 days. Registry to issue notice. Notice to whom? R1 and R6, huh? To the legal apprentice of spot number 1 and 6. Yes. Pass.
I'm for the serial number 17, my lordship.
Yes.
I'm for the petitioner appellant in this matter, my lord.
You have to pay the process fee.
My lordship. I'll pay by Monday, my lordship. Matter will be taken up after 2 weeks.
Process fee to be paid within 3 days. Registration notice thereof.
Much obliged.
Able to file paper because the first appellant this
4 weeks time granted to file the paperwork. 4 weeks time granted to file the paperwork. Yes. What about office objection?
Appellant is that I have filed a memo, I for the respondent, I filed a memo.
Sole appellant?
I've already filed a memo.
Sole appellant, huh?
I agree that.
Which appellant type?
First appellant is dead. He is dead. V.N. Nagesh is dead. I have filed a memo to that effect along with the death certificate.
When he died?
I have filed application, so for the section, office objection is not served, the copy of the application.
Donate advocate for the appellant to appellant submits that he has removed the office objection. Yes.
So for a second objection is concerned paper, not filing a paper.
4 weeks time granted. 4 weeks time already granted.
Much obliged.
Complied with him.
Why 1 week? What is the office objection?
Number is not mentioned.
Copy not, sir. Donate advocate to remove the office objection within 3 days.
Court has granted 2 weeks time may not to pay the process filed after 2 weeks, that is third week may not. When passing the order, there are options for passing an order that if the process is not paid, post for dismissal. Hence, in the process you are not issued, may not answer, filed an application for the order dated.
Order dated?
22 to 19. I paid the process, may not, that they are not
When
been
it comes
issued.
for the appellant would submit that he has paid the necessary process fee. However, the same is not paid in the stipulated date. And there was an order, preemptory order to dismiss the appeal. In case of the process.
Post for dismissal, the preemptory order has not been passed. Post for dismissal, it has not been dismissed.
Yes.
Before that, I have filed.
Advocate for the appellant submits that the process fee was not paid within the time stipulated in the order. Thereafter, there was one more order on 22/2019 to dismiss the appeal in the event of process fee not being paid within the stipulated period. Now the application is filed to recall the order dated 22/2019. For the reasons assigned in the said application, the order dated 22/2019 is recalled, registry to accept the process fee and issue notice to R5. Yes.
For non-passage. We filed application for recall that order.
Where is he? Also. Get him.
Respect to amendment or carry out the amendment. Respect to application for bringing a loss.
Why amendment is not carried out even after 3 months, 4 months? So that is a different story. What is the sanctity of this order?
During the course of carry out the amendment.
Also,
The application for R7 and R4 is served. Service completed this month. They also completed and carry out the amendment.
R4 and R7.
I hear about 10 to 12 and 7 to 7, 8 and 9 this month.
LRs of R4, huh? R4 is dead.
R4 is dead and R7 also dead.
They have been served.
Yes, please.
Which applications?
Application number 10, 11 and 12, 7, 8 and 9.
Note number in the cause list.
14, please.
14, huh?
14 and 17.
So 14 is for LRs of R7.
R7 service completed. R4, please.
Notice to the proposed legal representatives of deceased R4 and R7. Duly served. There is no representation. Is there delay? Application is filed to put the delay and set aside abatement to substitute the legal representatives. All the pending applications against proposed legal representatives of R4 and R7 are allowed for the reasons assigned. Appellant to carry out necessary amendment and furnish amended cost type.
Respect to R10 and R11, 3-time notice issued and file a substitute service.
Learned advocate for appellant would submit that for service of notice against R10 and 11 would file application for substituted service. 2 weeks time granted.
Carry out the amendment within this.
Number note clear.
Okay, for the appellant in serial number 23, my lord.
Yes.
I will I will pay the process fee with regard to issue of summons to the R6 by the end of the day today. My applications for bringing LRs of deceased condonation for delay condonation of delay and this may be allowed, my lord. I have also filed. There's an 878 days delay.
Against whom that application is filed?
Deceased
R1. Is it R1? R1?
R1, my lord. R1 and R18 is the he's the legal representative of R1.
No, IA 1 of 20 for bringing the LRs of deceased R18.
Yes, my lord.
No, notice to R18, proposed LRs of R18 served.
That's what I was seeking your lordship's leave to actually issue notice.
No, IA number 1 of 20, is it notice issued on that IA?
Issue agila Swami. Even I mean, with all due respect, I also came on this matter by NOC very recently. Notice
Current advocate for the appellant would submit that process fee for service of notice to R6 would be paid today itself. Registry to issue notice to respond number 6. All right. What about R1? Notice Hogaka?
Notice Hogaka Swami.
Registry to issue notice to the legal representatives of proposed legal representatives of deceased R1 and R18. Agidya, R1 estimate. Notice on I number 1 of 20 to bring the legal representatives of deceased R18 is served. There is no representation. For the reasons assigned, I number 1 of 20 is allowed. 1 of 20 is allowed. Appellant to carry out amendment and to furnish amended cost.
I'll carry out the amendment. Obliged.
Respondent, Your Honor. According to me, it is a stranger for me.
Sorry?
Stranger for me. Because he was not in 40 also particular. At the time of MTP, he included as an employer. So he went to the particular report in some 2007. Yes, the detailed objection was also showing.
On what basis is claiming right?
The respondent for 1 minute. And later on, it was not in our.
No, on what basis you are claiming right over the property?
I purchased the property.
When did you purchase? Prior to the suit or after the suit? Have you filed an application to seeking permission to prosecute this appeal? You have not filed application. Then Huh?
Actually, I came to know after filing FTP only, I came to the.
No, the question is, you are not a party in the suit, you are not a party in the appeal, first appeal. Now we are trying to prosecute the second appeal. You to file application seeking permission to prosecute the second appeal. Have you filed application? You have to file application. When? It's 2016 matter. Now, when FDP was filed? So if he has already purchased the property before filing the suit. No, he has purchased the property prior to the suit. Then he is a necessary party. No, understood. Your point understood. If he has already purchased before the suit is filed, then he should have been made a party in the suit.
Mother was filed and the suit against the other family. That suit is treated and 1/6 share.
Who sold the property to him? Who sold the property to him? Property belongs to whom?
Child family.
That is understood. Then he has got a share. His vendor has got some undivided share.
Yes, sir. Yeah. Every undivided share is 1/6 share. Now the share was sold to the property in favor.
Why it is listed today?
I got in the name because it is not, this is still it is pending.
You submit on merit on Monday. Only if you make out a case, notice will be issued. Otherwise, there is no need to take steps. At the most, you are entitled to a share in the property, not entire property.
Yes, sir.
You must demonstrate that your vendor had absolute right over the property. Then only I will grant you the permission to prosecute the appeal. The request of permanent counsel for the appellant is this matter on Monday.
Production of some document. Just 1 week time, why?
You are seeking probate in respect of whose will?
Probate is my mother-in-law, my lord, to begin my favor.
Mother-in-law has got a son or daughter.
She has a daughter and a son. Son expired.
Who is the respondent?
Respondent are my lord, I is the wife of the deceased son, and respondent number 2 is the.
But they are objecting. It has to be converted into suit now.
Evidence is recorded.
It has to be converted into suit. Section 295.
Recording
It was converted into suit.
Yes, after filing, they filing.
Where is the order?
Objections were taken and recorded and referred for recording evidence. But formally, it was supposed to be US.
Not taken place. Evidence is being recorded. Which document you want to produce now?
Only for photocopies are produced along with objections. I only want to produce the originals of those documents. Yes, produce.
I number 1 of 2022. I number 1 of 2022 is filed seeking permission to produce the documents. Learned counsel for the petitioner would oppose the production of a document. Learned counsel for the respondent would submit that the Xerox copies were produced in the first instance. Now the respondent is intending to produce the original. Original and certified copies. Under the circumstances, there cannot be an objection for production of documents. Accordingly, I number 1 of 2022 is allowed. Since there is objection to the petition filed by the claimant, petitioner, this petition is to be converted into testamentary suit. Registry to carry out necessary corrections in the papers. For statistical purposes, the case is discussed. Sir, for respondent, learned counsel for the appellant has no objection to allow I number 3 of 2022 filed by the respondent seeking early hearing. According to the of 2022 is allowed. This matter on 12 by hearing.
27, my lord.
27, yes.
I appear for the, beg to appear for the appellant. Yeah, the D10 passed away.
Sorry?
And R10 passed away. And I have filed application by
notice not issued. Notice not issued.
One submission. I have made a mistake. In spite of filing this application, I have filed 3 applications yet again today. But my submission to my lords is there was another lawyer that appeared for the same respondent. Now Mr. Anand is appearing for R8, R9, R10 to 11. He may be directed because they are all family members. That lady is working in the court only. Appear somara hakond final disposal maadu. Nanu tumba memo haki request maadi argument maadi our argument agdene iddaga avaru tirkondu. It's a very small matter. If the
just a second. R10 notice is issued to LRs of R10.
Madilla, sir. Madilla. That's the reason why I'm requesting my friend.
They have already filed wakalat.
No, they have not.
No, they have already filed wakalat. That's what the cause says.
R10 is dead. So they have to file wakalat for the legal representatives of R10.
Yes, that's what all this says. Yes. Anand N appears for R8, R9, R10, A to C.
Then I'm ready for final disposal.
You have filed wakalat.
I'm ready for final disposal.
You have no objection to allow the I number 1 of 2020. You have no objection to allow the application. Yes. Learned advocate for respondent number 10A to 10C would submit that she has no objection to allow I number 1 of 2022 filed to substitute the legal representatives of deceased respondent number 10. Accordingly, I number 1 of 2022 is allowed. Appellant to carry out amendment.
Yes. Somara Martini, can I request?
What is I number 2 of 2020 is for setting aside abatement. For the reasons that application is also allowed and abatement is set aside. Yes.
I'll file the amended cost title.
Matter is already admitted.
Admitted. Matter is admitted.
Yes.
Matter is
appellant to furnish amended cost title. This matter for final hearing.
Tuesday, Wednesday, if my lords were to kindly accept my request.
Madam, state. He says the matter was already argued once. Which date? Is this matter on 23rd? 23rd.
Great.
For final hearing.
Grateful. I will do the need.
Yes.
My lord, multiple IAs to bring the LRs on record of respondent number 1 and 3, my lord, and also to set aside an
notice issued. Notice issued.
Notice is not yet issued.
Registered to issue notice on all pending IAs. The proposed legal representatives of deceased respondent number
1 and 3.
1 and 3.
Grateful.
Appellant to pay the process. Two D na. What about 2 ABC? No, you don't represent them. You don't represent them. You have no objection to allow the application. Yes. Here I allow. Yes, all applications allowed. Appellant to carry out amendment. Yes. Is this matter for admission? Is this matter for admission? Just inform him, counsel for appellant. Inform him. They may not carry out the amendment. Just inform him. Yes. Who filed early hearing application? You have filed. Your objection? Yes. Learned advocate for appellant would submit that he has no objection to allow I number 1 of 2022 filed by the respondent seeking early hearing. I number 1 of 2022 is allowed. Early hearing granted. Is this matter on? 2nd January. Sorry? 4th January.
Prasanna Kumar.
For response number 1.
I've not been served with the including application.
You have filed implementing application? On what basis?
One Fatima and operate a gift deed, survey number 55 from the Muslim Shah. Says he has validated the property, the record. And another Sayed Saab validated the property to operate. Operate also rights in the recorded case, which are our property. I am producing the copies producer.
No, just a second. What is the property number? 53 and 54. Now, when did you acquire right over the property? Now, when did you acquire right? Have you been served with the copy of this application?
I have also not been served with the copy.
And this is the Fatima.
I have not been served with the copy because he is now claiming against me also. It's a suit for bare injunction, my lord.
Learned advocate for impeding respondent to serve the copy of the application to the advocate on record for the respondent. This matter. Respond number 1. This matter. Madam, you have received the copy.
We have made an amendment in our with respect to she have filed an OS for
Whatever. Have you received the copy? Yes, verify. This matter after 2 weeks.
Even before I had filed an entire application with respect to the appellant C. Malik Ajimuddin, whose date that's not been put up. I have filed it on 30th of March.
Register to put up the LR application filed on behalf of appellant number.
Appellant number 3.
C.
3.
Appellant number 3. Notice ಹೋಗಿದೆ ನೋಡಿ. Notice ಹೋಗಿಲ್ಲಲ್ಲ. Issue notice on item number 3 of 2022 and 4 of 2022 to the respondents. Sir, for appellant. So argue the matter.
My colleague mentioned it by mistake.
All right, you can argue the matter.
There are 2 appeals. 1850 and 1850.
1850. That is not listed today.
Yes, there are both of them. 1850. 1851.
Only 1851 is listed.
1851.
No, respondent counsel was present when this case was mentioned. You're there. All right. So what is this GPA holder? In the cause list, it says Cyril Prasad Payas by GPA holder. What does it mean?
Statement.
Yes.
Explain this. Underlying tax bill for insurance. There is a property which also on 31st 12/2005, agreement to state the understanding as per the agreement to state is that the period of 21 days, that is on 31/1/2006, this 18 have been executed. Now on 14/1/2006, there is an addendum by mutual understanding levels.
On which date?
On 14/1/2006.
14/1.
14/1/2006, the parties entered into another addendum. And as per the addendum levels, it is agreed that the sale will be executed by 21/1/2006. When this took thus
21/1. 1 month was extended.
10 years is executed.
All right.
31/1/2006. Now, what also appears to have happened is that in the original agreement, I have a copy, the appellant tenants who are the tenants of the property, they will give us a Xerox copy of the agreement. The original.
Is it a residential house or commercial property? Residential.
It's not a apartment, it's not a now, it so appears that on the Xerox copy, which is the original agreement, there is a further addendum that was entered. As per that addendum, it is understood by the parties that the sale will be executed by 2006. Now, the overall understanding was that in the earlier addendum, it was understood by 31/1/2006, the sale will be executed, in which I, the appellant, the tenant in the property would vacate the premises. Now, 2 months after 31/2006, there is a notice that I received from the respondents that said that I must vacate the property. I replied to it, I specifically gave the attention.
So when you received the notice, you still had the time to pay the balance consideration amount? You still had the time. Extended time was available to you. Extended time was available to you.
And therefore, the earlier, the first agreement what were the next. And therefore, I need to be now, one suit for possession is basically filed by my law. I file a suit for specific forms thereafter. Both of these methods are clubbed together and a common order is passed. Now, in respect to methods, the suit for possession methods doesn't have an execution. Therefore, my 1850 methods is the RC is not survived.
So we have already vacated the premises.
I have vacated the premises. Here, 2011, there is an execution of share. Now, in respect to this suit for specific performance methods, I can want to for 2 grounds. First one, the learning trial court says one. Learning judge says that this particular secondary addendum is reflected as a Xerox copy produced by me. That is the addendum. That is the appellant. It appears that the signatures are not correct. How the trial court arrives that the conclusion is on the basis of section 73. So that I will magnify and ask on the basis of which it appears to me that the signatures are shaky.
Signature is?
The signature is shaky.
Shaky. Yes.
He says that the signatures are shaky. Second thing he says is that the respondents have produced the original agreement. In that original agreement, there is no addendum that is there. These are the 2 grounds on the basis of the suit is rejected. The third ground is that I have not shown values. So the entire tenor and gamut of
the trial court says that the second addendum is not established.
It's not established, it says that it is probable.
Though it is Xerox copy, it has compared the signature on its own without the assistance of the expert. What is the finding of the first appellate court?
The first appellate court also goes in the same grounds. The first appellate court was that I will magnify class. I look at both the signatures, appears to be shaky. Appellate court agrees with what the learned trial court says and holds that.
Whether both the courts have held that the document being Xerox copy is inadmissible in evidence. Document being Xerox copy, it is inadmissible in evidence. It's the finding of the first appellate court and the trial court.
The objective for the question will be applied by way of Now, my secondary evidence was I have to be there's nothing else on the top. But mine.
So have you laid the foundation for leading secondary evidence? And according to you, who is having the custody of original? According to you, original is with whom? Is it pleaded by you? Did you issue notice to him calling upon the original, him to produce the original?
I challenge my custody from the logistics. One is those are the Indian methods for taking on the second round, even though the bank manager is someone who shown to be made, that I did not have sufficient balance on that day, and other lending companies which I was.
So just a second, for how much the property was agreed to be sold?
6 lakhs.
6 lakh. There is a date of agreement. How much you paid on the date of agreement? Then
Subsequently, there was on 14/1/2006, when the addendum is entered into this, I pay an additional sum of 30,000.
30,000. Then
Then there was subsequently thereafter, it is likely that there is a further addendum extending the period for execution of the sale. Till March 15/4/2006.
15/4.
Yes.
When he issued the notice?
Because he issues his first notice on 4/3/2006. My response is on 10/3/2006.
All right. When he issued the notice on 4/3/2006, the time provided under the first addendum that had expired. So when that time would expire?
Because that time would expire on 21/1/2006.
All right. Now you are required to pay around 5,50,000. You have produced the bank statement.
I will not produce the bank statement, but in my notice, as also in my evidence, I have stated that as per the extended period methods, at that given point in time, I had such. But apart from that methods, I have also stated that I have other landed properties. Now, if I produce.
Landed properties where?
In Kerala.
Kerala.
But I have not produced any state methods.
Now where are you staying? Now where are you staying?
I methods I stay in
Bangalore. You own a property now?
my methods, the property is in Bangalore.
No, you presently own the property in Bangalore.
I don't know the I have an auto.
You are still banking on this.
But my lords, I have an agent, my lords, that takes commission in selling vehicles. So that is some substance in my liability.
Is there a decree for refund of the amount?
That is specifically now, even though I will not by both courts, the appellate court comes to a finding that refund of honest money may not be granted. I have not made a specific.
It's not required.
It's not required, my lords. I've also. So even if my lords are non-suit, I accept the verdict of the high court.
So what is his defense? He admits the first agreement.
He admits the first agreement.
He admits the addendum. Yes.
Goes on to say that the
All right, sir. How do you retain the money? How do you retain the money? Let us say that he has not made a claim. But what is your responsibility? What was the rent? 4,000 per month. In the decree for possession, is there a decree for ascertaining the mean profit? You filed a petition put for possession on the premise that he is in arrears. What was the arrears? 48,000. Now, how much you have received? No, all right. No, all right. What the decree says? Is there a prayer for recovery of arrears? What the decree says? Is there a pay for recovery of arrears? No, did you pay the rent? The case was pending. You are not paid. How much? In the execution, have you recovered all the arrears? All right. What happened in execution proceeding? What about arrears? No, did you take steps for recovery? How do you say that? What is the final order in execution proceeding? See, there's a decree for arrears of rent also. There's a decree for arrears of rent also. Decree further says that you have to pay the rent of rupees 4,000 per month till the date you hand over the possession. But do you say that you have paid the amount? Now, from experience, I can tell that such amount is not paid. Usually, when the case is pending, tenant will not pay the amount. Now, what are your instructions? No, understood. You are entitled to recover the earnest amount. There is no difficulty. But you being a tenant, you are also liable to pay the rent amount, agreed rent, and there's a decree. So, if you are able to show that you have paid the arrears of rent, then only then I can order for a refund of earnest amount. Otherwise, not.
He sticks himself only in possession of. Then he come around
when the decree was passed? 2000? When the execution was closed? Just a second. If it was closed in 2011, you can still file one more execution petition because you handed over possession 2011. Successive execution petition is permissible. There is no question of order to rule 2 or if it is in arrears, why should this court should pass an order for refund of the amount? You are in arrears. All understood. Instead of passing 2 decrees for recovery of the amount payable to each other, let the court ascertain the amount payable to each other, then pass an order. Monday. You ascertain as to how much amount you have recovered. You also ascertain as to how much amount you have paid. Otherwise, no case for admission except for question of refund. Right? What's your name? This is not on Monday. Awesome. When an advocate for the appellant would submit that there is a proposal for settlement. List this matter on 6th December to report settlement. Interim order granted if any stands extant. Settlement, I think just now we made a submission. Just now we made a submission that there is a proposal for settlement. It is adjourned to 6th December to report settlement. Password. Password. Yes. The plot number 8 and 9 dispute. Where is he? Password. Password. Yesterday I argued this matter. Sale agreement executed by only one person in respect of properties belonging to 8 persons. Yes, where is he? Password. Ex parte decree. The report doesn't say that the process server was not examined before the court.
That is the reason for us I have not been ultimately brought to an application, but I have not the Congress of after the period. The name was not shown.
Have you filed application to recall the order?
No, I very competent to verify an application to recall the order and to my objections.
Just a second. Who died? Appellant died. Now, who is coming on record now?
He has got a daughter. Absolutely, there is no adoption data or nothing. She is highly unknown to the family. Unknown person to the family. She has got a will and personally going to the office. I came to know that she has got a will. But I don't know whether the will is valid or validly executed or whether the will is
Now, who is claiming to be the negative appellant?
She is nobody now. She is nobody to the family.
All right. She claims to be adopted daughter. And she also claims to be a legatee.
That I don't know because I am not sure because England, when he directed to serve the copy of the application and we notes that
You have not served the copy.
First, I filed my orders in the year 2017.
In case if his name is not shown, then yes. Just a second, we verify. All right. Then I don't insist for a formal application. I don't insist for a formal application. Learned advocate. Learned advocate for spot number 1 and 2, na? Spot number 1 and 2 has filed wakalat on behalf of respond number 1 and 2 on 22nd March 2017. However, his name was not shown in the cause list. Name was only part. Name was first respondent was shown in the cause list. An application was filed by the appellant on which date you filed application? LR application. An application at I number 1 of 21. 1 of 21 is filed by the learned advocate for appellant reporting to substitute the legal apprentice of deceased appellant. This court-wide order dated 2010-2022 has allowed this application. Apparently, on that day, the name of advocate for respondent number 1 and 2 was not shown in the cause list. It is also forthcoming from the record that copy of this application at I number 1 of 2021 is not served on the learned advocate for the respondent. This fact is now brought to the notice of the court. Under these circumstances, this court is the view that order dated 2010-2022 has to be recalled. And this I number 1 of 2021 has to be considered only after serving the copy of this application to the respondents number 1 and 2. Learned advocate for the appellant to serve the copy of I number 1 of 2021 and list this matter. To hear on LR to hear on I number 20 of 21 on 24th. Are you claiming that your applicant who is now wants to come on record is claiming under a will? All right. Those things, no, if those things are disputed, under law there has to be some formal inquiry. Or else we'll only say that the application will be allowed only for a limited purpose, without upholding the validity of it, for limited purpose of prosecuting the appeal. No. You can only say that the appellant has to establish the will and the adoption in case if it is disputed in an appropriate proceeding. Appellant will be permitted to come on record only for a limited purpose of prosecuting this appeal. Right over the property has to be independently established by filing a suit based on the will and adoption. That is the position of law.
One more submission. If there was a partition, suppressing the fact was right, and by giving a wrong address error, they have been made as expert for the money. Appeal
So simple logic. If your case is good, fight on merit. Don't stand on technical.
Even one aspect of my friend is wrong. My friend is actually because the address of the applicant shown in this example, the same address for what I have from this suit. So how can my other friend address?
What happens is the different address is shown, registry will not accept. Registry will come out with.
There was a partition. After the death of the husband of the appellant, you filed a suit.
Now the question is whether the notice of the suit was properly served or not. That is the basic question.
Whether it is service proper and the other part the appeal over itself, the appellant, the appellant is the process has to be restricted to there are several properties which are reserved in the joint name of the party. For that I have made a simple partition. probably my friend is suppressing that aspect and towards driving this court in a different direction. Let me show those things.
No, this court is only examining whether he was properly served or not. If it is properly served, then the case has to be adjudicated on other aspects. If it is not properly served, then there is scope for setting aside the judgment and decree and to remit the matter back to the trial. Order record on Mantala. Order record on Mantala. Order dated so and so record on. This IA melbadu. Further in bedai. Aden beda.
Last year, your lordship had ordered for evidence to be let recording. That was on 9th of November. So, probate doesn't have a copy. Now,
Evidence was recorded.
9th of November. One attesting witness was there.
This petition is filed. Under section 222, 273, 276, and 300 of Indian Succession Act 1925. Stop. The prayer is to grant probate. The prayer is to grant probate in respect of where is the reference to the will? The prayer. Prayer is to grant probate. In respect of the properties of Subramaniam. Stop. The petitioners have sought probate in respect of will. Must mention the date and details of the will in the prayer column. The will alleged to have been executed by late Shiva Subramanian on 14/10/2011. According to the petitioner, the will is duly registered before Sub-Registrar Virugambakam, Chennai. Stop. The original will is produced before this court. Wow. The will is attested by two attesting witnesses. One of the attesting witnesses is examined before this court. He has identified the will, has identified the signature of the testator, he has identified his signature as well as signature of another attesting witness. The attesting witness has given evidence relating to the attestation. This court has ordered publication of citation. The citation was duly published in Indian Express Chennai edition, Indian Express Bangalore edition, and Udayavani Bangalore edition. There is no objection to this petition. The petition is filed by two executors. Beneficiaries are two executors who are also the beneficiaries under this set. How many beneficiaries? In addition to the petitioners, there is one more beneficiary by name Mrs. Anuradha Shivasubramanian, who is the daughter. The petitioners are the sons of testator. Stop. Next paragraph. The properties covered under the will are located in only Bangalore. In Chennai. Chennai. Stop. He passed away in Bangalore. Huh? The petitioner died in Bangalore. The death certificate revealing the date of death and place of death is also produced. Stop. The petitioner died on 4th January 2021. Stop. The death certificate reveals that the petitioner died in Tobrahalli, Bangalore East. Stop. So the court gets jurisdiction because of his death in Bangalore. It is also stated that the petitioner was residing at the time of, in Bangalore at the time of his death. Stop. There are no materials to disbelieve the claim of the petitioners. Stop. This court has produced the original will produced for the court, and also, where is the original will? The court has produced the original will, also the death certificate. Under the circumstances, this court is of the view that there is no impediment to grant the probate respect of the properties shown in the schedule to the petition, which are the properties covered under the will dated so and so, executed by date Shiva Subramanian. Conditions are like that. What you have shown is Shiva Subramanian. That is not there. In your petition is Shiva Subramanian Balaji. Where you have mentioned? Yes, R. Shiva Subramanian. To execute the bond. Not basis. Why?
You need third parties in this case, not the petitioners themselves. Third parties are required to provide the third party authority as to execute. For 94 lakhs, complete compound.
That cannot be the reason. Now, where it is required, where it is not required, where you have cited the judgments. Where is it? It's not here. Give your copy. Under what circumstances can be dispensed? No. No. Execution bond is under which rule? Bound by which rule? Rule of?
Administration manual rule. It is section 291 of Indian Succession Act.
This is not a judgment. Have you filed IA here?
This was in a letter of administration. There because
Now, what the rule says?
Filing of the administration law. So it starts with every person who makes grant of administration other than a grant under this one. So grant of probate.
Which section?
One.
What is 241? What is 241?
Administration will annex colony of asset executor. So this is in the case of filing of letters of administration, the executor is not present. Appointment of a new executor.
Where any executor is absent from the state means the application is made. There is no executor within the state willing to act. Letters of administration with the will annexed will be granted to the attorney or the. So in that event, the administration bond is not required. The case covered under section 241. Two 276 doesn't specify anything about
And rule 17 is the procedure.
we have to file the list of inventory. Yes. Except administration bond, all the conditions. Allowed. Other? Other. Wait a minute. Wait a minute. Allowed.
Fine, Prakash. Fine.
You are for appellant? Ahmed. Ahmed allowed. Yes. But author medido. Author medido. You are ready?
Ready.
Ready ಇದೀರಾ ಅವರಿಲ್ವಾ ಬರಲ್ಲ ಅಂತ ಹೇಳಿದಾರೆ
one day ಆಗಿರೋದು ಅದು
ಮೊನ್ನೆ ಅಲ್ವಾ ಅದು ಮೊನ್ನೆ ಬರಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಸರಿ ಆಲ್ ರೈಟ್ ಯಾರಿಗಿದೆ ಮ್ಯಾಟ್ $38 is parted, right? Yes.
The suit of the declaration of possession. In respect to the schedule property, the house property. This house property was purchased by the unlike in the partition, they got this share of property. The family. This property, house property was purchased on under a registered civil date like that 30th of March 1953.
30th March.
30th March 1953.
Rent his father purchased. Rent his father purchased.
From one Kuntaya.
Yes.
The property is house property.
Yes.
Maintaining 165 feet on the east west,
Yes.
39 feet on the north to south.
Oh.
But in the scheduled property and the sale deed, a portion of the property is responsible to where the dependent's father was allowed to stay for some time in the premises.
Not in entire property, in a portion of the property. In which year? In which year?
It's because after sale of the property,
In which year?
it's the same 53.
Oh. Dependent's father, a relative or a stranger? Stranger. Okay.
No,
Yes.
no other property related relations.
All right.
But if I find my definite case is that I have one with my father, he was allowed to stay in a portion of the premises at the house. Now, after a long time, now when I made a request, I made a demand for vacating and handing over. His father never made any transfer. His son has continued to reside in the place in the same portion. Then on my request, my demand, he has refused to vacate and he has made adverse claim on the property.
All right.
Adverse claim he has made.
All right.
Therefore, my client, my candidate related is in the main number 2. But the substitution government will call part of punishment number 1 at home. And it is the owner and ask the dependent to give possession. Initially, dependent go agree to vacate and he has been set up some purpose to claim hostile right to himself. The dependent is not owner and he does not have any right or any kind of interest.
All right. What is the defense of the dependent? Oh, just a second. Whether your sale deed reveals number 165 to 34?
Yes.
There is no dispute.
There is no dispute.
All right.
Now, what is his stand by way of defense? His stand, now he says that in Karnataka, the last portion, page number 4 of Karnataka. Paragraph is a statement. In the second paragraph, last but third or fourth, the said Malayikapa are made to have not and could not have derived any right in the said property. Said Malayikapa are any of their family members were not in possession of the said property or any part of it. The alleged document, now it is with the alleged document, there are 13 is not a sale deed.
Yes.
They have been fraudulent deed, and it is not finding another dependent. Dependent has been accidentally posted for. So when they come to the
So they deny the sale deed.
India is a sale and also he has contended and he has set up a case that it is a fraudulent document.
Yes. Ah.
The further allegation that said property was purchased father from Munkaya is false. The allegation that Munkaya and different juncture later are false. The said Munkaya has no right to sell the said property as alleged. Even if the said property, the ancestral property of said is dependent and his brother. There was no family and there was no family and legal history. The alleged sale is illegal, fraudulent, and concocted with an ulterior motive by the plaintiff's father, and he has no not have the right and interest in any portion of the said property under the alleged document. Dependent father was also no right to create any alienation in this property. As a dependent and his brothers were all minors and the alleged alienation is what is low. But it was also no knowledge of the alleged alienation.
Yes, I read it. How they claim right title of the property, that is not established. It is not pleaded. How they claim right of the property is not pleaded.
It is not clear. And he has set up by making a positive assertion in the witness statement. It's a product of the transaction.
All right. Adverse possession not pleaded.
That was not clear.
How they acquire title of the property not pleaded. They say that your sale deed is concocted. Yes.
My brain is also so different and so accurate. Because of this adverse claim they have made,
All right.
my brain is clear.
You have produced original sale deed.
Saying it is separate of
Where is the foundation in the pleading?
and the feelings,
In your plain, do you say that original is not available?
is that this original certificate they have mentioned, but okay, go to the number, date, etc.
No. Because the requirement under law is you have to plead in the plain that original sale deed is not available. That is the requirement. See, for reducing the secondary evidence, you must lay the foundation. It can't be straight away produced as a matter of right. Requirement under law is you have to produce the primary evidence. The primary evidence is not available, then you must lay down the foundation for producing the secondary evidence. That is the settled position of law.
And in case now, in case if you are, and you said that technology is not mentioned in the pleadings, that technically is approach. So what my last said is fine. Where the primary evidence is not available, secondary evidence, I can substantiate and I can also.
See, now the allegation in the written statement is the sale deed is not executed, sale deed is concocted. And under these circumstances, it is incumbent upon you to produce the original and to produce the through the signature. When they say it is concocted, it is not executed.
That's their statement because the partner is those who make such an allegation that it is a contract.
No. See.
Even for the sake of argument, now, what they said is I could not produce it because it has been marked in the file or by the
No, that is to be established.
The more levels are stated, but in the previous order is stated by the when it comes to rapid in the rural local society. Of course, now sometimes it happens too technically you cannot go. Now by virtue of fire, my sale is bad or it is lost. Then after the secondary evidence I have to read. That the secondary evidence are right. Now this is my period. I propose to put the on the court.
No, whether secondary evidence is led in accordance with law, that is the question.
Secondary evidence is
Led in accordance with law.
Yes,
that is the question.
I can also take the portion where I have taken. And now you are forgetting about all these things which I have to take better. Now is the definite stand is a fraud. How fraud is to be done?
That is a secondary thing. See, you have filed a suit for possession based on title. To succeed in this matter, you must establish title.
I must establish its partner is on me. Now, in case of absence of its primary evidence, it's a registered dispute. It's a registered dispute and section 17 of the Register Act. Where the presumption is, unless it is contrary to the document is genuine, and it has to the right has to accept it.
No, it's not like that. It all depends upon the nature of defense taken by them. The defense is the document is concocted. There is no execution of sale deed by Kuntaya. The first thing you are required to do is, because it is your suit, you are claiming title based on the sale deed. First thing that is required is you must produce the original sale deed. You must prove the signature of Kuntaya. You must prove the execution.
The execution I have to prove it is not because in 1983 document where my father is no more. Me this to prove the document.
Any witness is examined to the execution.
In both sides, no witness.
Then there were two deeds on the same day within a span of 5 minutes.
And one document they say it is on 1956. Another document is 33 My document is 1933.
Madam, is it the same case where the documents are executed within a span of 5 minutes? Same case. So what you have so far contended is, in your written statement, you don't say that how you acquired right over the property. What you have said is, execution of said deed by Kuntiya is denied. It is concocted. What is the basis for you to stay there in the property? What is your right in the property? That is not pleaded in the written statement. That is his contention so far. That is understood. No. What you have said is, you have denied the execution of document by Kuntiya, the plaintiff, dependent, and they are not established as to how they are in possession of the property, on what basis they are in possession of the property, what is their right over the property. These facts are not established by them, not pleaded by them. This is the sum and substance of your argument. I conveyed to her because she was not present yesterday. You can continue. Yes, continue.
Now, let us talk about this original document. I made the document in the event of now the second
No, secondary evidence is admissible and permissible, provided grounds are made out for leading secondary evidence.
I have to lay foundations. Why I am using this document? What that by leading evidence.
They have admitted the signature on the sale deed. Then there was no need to produce the primary evidence. The signature is admitted, then there is no need. No. The signature was admitted, there was no need to produce the primary evidence. So the very execution is disputed, signature is disputed, then it is required that you should produce this primary evidence.
Now, in the details also, there is no wording of the execution. They say that the legal document is not a sale deed. It is being product and constructed and it is not finding under the correct manner. What my lord says is that execution is delayed and signature is delayed. That's a different aspect. Then more burden is on me. The alleged document dated 33/18/23 is not a sale deed and it has been fraudulently constructed and it is not finding under different has been materially in portion receiving the members of the family in its work, right?
Yes.
And there is a whole rate of a period and there is a connecting code also. Now,
Yes.
again, I have been at
Yes.
the other allegation that the said property was purchased from the plaintiff's father from one Kuntiya is false. Or specifically, it is false. The allegation that they Kuntiya and different respectively are false. The said Kuntiya has no right to sell the said property as alleged. Now they claim that they have no right. Even if any, the said property is the ancestral property of his dependent and his brothers. There was no family and legal necessity and alleged said if any is illegal, fraudulent and concocted with an ulterior motive by the plaintiff's father, and he has not and does not have any right.
Yes. Yes. Yes.
And again, he said that in the last two lines.
Now come to the evidence. Come to the evidence.
Combination is why. It is not when he has repeated, he has taken the he has to take and he has to lead evidence in support of his feelings.
Yes.
Now, let me get to the next video.
Yes.
PW1 matter.
Page number? Don't read the examination chief. No, don't read entire examination sheet, no point. Read the cross-examination, whichever is in your favor. So being the defendant, you read the cross-examination of all right, you appeared for plaintiff, right? You read the cross-examination of defendant. Don't read your examination sheet. Oh. Correct.
ಖರೀದಿ ಮಾಡುವ ಸಂಬಂಧ ಇವರ ತಂದೆಯವರು 12/3/57 ಮಾಡಿದ್ದು ಅದರ ದೃಢೀಕೃತದಲ್ಲಿ ಹಾಜರುಪಡಿಸಿದ್ದು ಅದೊಂದು ನಿಶಾನೆ SDE ಎಂದು ಆಗಿದೆ. ನನ್ನ ತಂದೆಯವರಿಗೆ ವಾದಿಯ ತಂದೆಯವರಿಗೆ 26/3/53 ಕ್ರಯಪತ್ರವನ್ನು ಸದರಿ ಕ್ರಯಪತ್ರದ ದೃಢೀಕೃತದಲ್ಲಿ ಹಾಜರುಪಡಿಸಿದ್ದು ಅದನ್ನು ಈಗಾಗಲೇ ನಿಶಾನೆ ಡಿ ಮುಂದೆ ಮುಗಿಸುತ್ತಾರೆ. ನನ್ನ ಕುಟುಂಬದ ಸದಸ್ಯರು ನನ್ನ ಹೆಸರು ಮತದಾರ ಪಟ್ಟಿಯಲ್ಲಿರುವ ಸದರಿ ಮತದಾರ ಹಾಜರುಪಡಿಸಿದ್ದು ಅದು ನಿಶಾನೆ ಡಿ ಮುಂದೆ ಯಾವ ಸಂಖ್ಯೆ ನನ್ನ ಕಾಲಕಾಲಕ್ಕೆ ಕಂದಾಯ ಒಟ್ಟು 17 ಕಂದಾಯ ರಸೀದಿಗಳನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದು ಅವರು ಕ್ರಮವಾಗಿ ನಿಶಾನೆ ಡಿ 4/26 ನನ್ನ ಹಾಗೂ ನನ್ನ ಕುಟುಂಬ ಸದಸ್ಯರ ಹೆಸರು ಮತದಾರ ಪಟ್ಟಿಯಲ್ಲಿರುವ ಇನ್ನೊಂದು ಮತದಾರ
Just a second. Madam, you claim to have purchased the property. There is no such difference in the return statement.
You said that they purchased from the plaintiff's.
Where you have said in the return statement. There is no such difference. No, what you have disputed is his purchase, which he has claimed under the 1953 sale deed. Yes.
ಆಮೇಲೆ ಒಟ್ಟಾಗಿ ಅದಲ್ಲ ಈಶಾನ್ಯ ಶ್ರೀ ಒಂದು ಹೇಳಿರುವ ಹಿಂದೆಯ ಒಂದು ಮನೆ ವಿಚಾರ ಅದೇ ರೀತಿ ಈಶಾನ್ಯ ಶ್ರೀ ಒಂದು ಹೇಳಿರುವ ಪರಿವಾರ ಈಶಾನ್ಯ ಶ್ರೀ ಒಂದರ ದಾಖಲೆಯನ್ನು ನಾನು ನೋಡಿಲ್ಲ. ಈಶಾನ್ಯ ಶ್ರೀ ಒಂದರ ದಾಖಲೆ ನಾನು ನೋಡಿಲ್ಲ. ಈಶಾನ್ಯ ಶ್ರೀ ಒಂದರಲ್ಲಿ ಯಾವ ಆಸ್ತಿಯನ್ನು ಆಟ ಮಾಡಿದ್ದೇನೆ ನಾನು ತಿಳಿದುಕೊಳ್ಳಬೇಕಾ? ಆಗ ಈಶಾನ್ಯ ಶ್ರೀ ಮುಂದರಲ್ಲಿ ಹೇಳಿರುವ ಆಸ್ತಿಯನ್ನು ನನ್ನ ತಂದೆಯವರು ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ ಹೇಳುತ್ತೇನೆ. ಯಾವ ಆಸ್ತಿಯ ಬಗ್ಗೆ ಅನ್ಯಾಯ ದಾಖಲೆಗಳು ವಾದಿ ಹೆಸರಿಗೆ ನಿಜ, ಆದರೆ ಯಾವ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದ ನಾನು ಸ್ವತಃ ಹೇಳುತ್ತೇನೆ. ಯಾವ ಆಸ್ತಿಯ ಅನ್ಯಾಯ ದಾಖಲೆಯನ್ನು ವಾದಿಯ ಮೋಸದ ವಿಭಾಗ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಅವರು ಜೊತೆಗೆ ಸಂಬಂಧಿಸಿದ ಸರಿಯಲ್ಲ. ಯಾವ ಆತನೇ ಯಾವ
No, why do you say that exhibit D3 to D21 are not the property, the documents pertaining to the suit property? What basis you say so? What are those documents? Taxpayer receipts? Taxpayer receipts. All right. All right.
Then coming to the next one. Now ask the content
You purchased property from Kuntaya, dependent's father.
And it is contracted document, and it is not at all executed. Now, when we have set up the burden is on the dependent to show that it is a part of document, and section 7, one of the contract as far as to prove that dependent when you have definite stand that you have not placed any material, independent material, acceptable evidence, because I am a trial court to establish and believe that yes, that some change and mention of suspicion have been taken care. Now the higher document except the date and the requirement.
Both the courts have concurrently held that you are the owner. They held that you are the owner.
I am entitled for declaration of my name and also possession. Now I have a question about this document what they have filed some of its case, and I am not remember.
D1, D2. What is exhibit D1?
D1 is the sale deed of 1950. This is.
By whom? By whom? Sale deed executed by whom? In favor of whom?
In favor of this bank.
No. Document produced by defendant. I'm asking question about the document produced by the defendant, particularly exhibit D1 and D2. What are those documents? Who executed those documents? In whose documents are executed?
The first document, this was executed by my father. The first document is guided to conduct Kunte, Bhavatu, in the private.
Whether your father has executed any document in favor of defendant?
And don't say 1953 is one document. Exhibit D1.
What is that? That is D2. Sale deed is marked as exhibit D1. What is that sale deed? Executed by whom? In favor of whom?
This is 1953.
Yes.
The document is
So this is a document executed in favor of father of defendant, right?
that's the father of defendant. In favor of this plaintiff's father.
No. It is reverse. Plaintiff's father in favor of father of defendant.
My father.
So what is your defense to this document? What is your stand in respect of this document?
I did not.
No, that is the basis for them.
The basic of the schedule and boundaries I have to look into that. Immediate and it have to look into.
So this case is listed for final hearing. Then further hearing. Then further hearing. You are not present. On 2-3 occasions you are not present. This is final hearing matter, sir. 2-6 matter. Appreciating your honesty, the case is adjourned to Monday. Let him study. Tuesday. Now you have understood the case. What they are trying to say is, on the same day there are two sale deeds. One in favor of your father, one in favor of their father. And in the cross-examination, you have not attacked that document. Tuesday. After hearing for some time, the learned counsel for respondent seeks a short accommodation to address the argument further. Justice matter on Tuesday. No further adjournment on that day, sir.
respondent
Yes.
for this case.
Where is counsel for appellant?
I appear for the appellant.
46. RSA.
I'm sorry, 39, I thought 39.
39, the case was called, you are not there.
Right, I was watching.
No.
38 was
called.
going, 38, board shows 38.
Not now. Around half an hour ago.
Oh,
Maybe
sir.
1 hour ago. Pass over agide.
Please, I'll wait.
Your opponent is not here. Yesterday, one of your partnered matters was listed. Again, when the case was called, you are not here. And he said that he's going to file an application for production of driving license and insurance policy.
Yeah.
So for this reason, yesterday's matter was adjourned.
The problem is the display is not properly showing. It's not updated.
All right. Pass over agide. You can come at 2:30.
2:30. Oh.
Yes. Is he present? Pass over. Pass over. Ah. 2007 matter. No adjournment. When it was filed? It was filed in 2007. In any case, that the application for production of additional document will be heard along with the merits of the matter. I number 2 of 2007 is to be considered along with the merits of the case. In the meantime, the appellant respondent can file statement of objection, if any. So where is counsel for appellant? Pass over. Please inform me. Pass over. Pass over. Yes. No problem. Yes. No problem. I heard him only for 2 minutes. What he said is, an agreement for sale was executed by one lady, and there are 9 owners to that property, 9 joint owners. The suit is decree 8. The court says that the mother has executed the agreement for sale. She has utilized the amount for the benefit of children, so the agreement is valid. Is the only point?
So what happens is they are denying the agreement. She says she's a Parthanashin lady and she signed the agreement. She had taken a loan. It is a loan transaction, and it is not a sale transaction. This is the defense. The other defense is that what my learned friend said, that the children have not signed the agreement. Admittedly, I cannot change the fact that children have not signed the agreement.
The property owned by whom?
The property belonged to this lady's husband. He passed away. The wife and children have, it is a Mohammedan family.
Inherited the property.
Inherited the property. My lords, may kindly say, what has happened is the trial court dismissed the suit on this ground only. That
all the owners are not signed.
All the owners. The appellate court has taken a view. My lords, may kindly say, I take my lord to that finding of the appellate court. Yes. My argument is, my submission to the court is that the finding of the appellate court is correct. Page 91 of the paper book.
Yes.
Page 91, that is paragraph 14. The learned trial judge wrongly accepted the untenable contentions based on it. At no stretch of imagination, the transaction between plaintiff and defendant can be treated as loan transaction. It is an undisputed fact that the defendants have received a sum of 55,953 on the date of the sale, and thereafter by making an endorsement has received a sum of 2,000.
Just a second. It's an undisputed fact that the defendants have received. All the defendants?
My lords may take it as only this lady only. I will come to the how they are bound by the agreement. I will.
All the defendants are made parties now?
All the defendants are there. And that they have filed a written statement, and from the written statement they get bound. The written statement that they have filed, there itself, I'll take my lords. She has received a sum of rupees 2,000 on 10/5/1991, and again she has received a sum of 3,000 on 12/3/1990 by making an endorsement. It is the case of the defendant that they availed loan from the plaintiff as they were in need of finance for the performance of marriage of one of the daughters of first defendant. If really the transaction was a loan transaction for performance of marriage of the daughter of the first defendant, the defendant would have received entire loan amount from the plaintiff on single occasion instead of receiving the amount in part. Exhibit 330, the sale agreement nowhere discloses that it is a loan transaction. Therefore, the learned triangle have been appreciating both exhibit 13 and 320, the sale agreement, and he has wrongly come to the conclusion that transaction.
So what is exhibit P13?
So there are two agreements. First agreement, that is 1991. The 1911-1990. And there is another agreement which is not subsequently this thing which is called a Oppandada Kararu Patra 25/8/1991. It is not that there is only one agreement, there are two agreements.
29?
The first one is 1911-1990 and the other one is not 28/5/1991.
Yes. 7 months later.
7 months later.
Both signed by the mother?
Both signed by the mother.
Only mother.
Mother and one daughter. One daughter has signed.
And all the children were major.
Clearly disclosed the different one for and on her behalf of children had executed sale agreement agreeing to sell the procedural property for a sum of rupees 90,000 so and so in exhibit 330. The earlier agreement dated 1911-1990 is also referred to in that agreement. The subsequent agreement she refers to the earlier agreement. Now, my lord may kindly say.
Why two agreements are executed?
But subsequently, she wanted more money. She wanted another advance. So another agreement was entered. That is.
No.
Now what my lords will kindly take the written statement. It is at page 5 of the paper.
A common written statement filed by all?
It is adopted by the other defendants. Written statement filed by the first defendant. By filing a memo, they have adopted the same written statement.
First defendant is mother.
First defendant is Rabia B. My lords will kindly, it is at page 5. Second paragraph about 3 lines from the top. I being the widow and Pardhanasheen lady had borrowed in all a sum of 60,000 from the plaintiff and permitted the plaintiff to harvest the crop with the intention to repay said amount after taking into account of the reap and harvested crop. The said transaction the plaintiff obtained signature of defendant number 1 and the same have been fabricated to the convenience in order to make a wrongful gain by causing wrongful loss. This is her defense. Again, in the paragraph 3, she again says with the Pardhanasheen lady and she never agreed to sell the property. Kindly take paragraph 4. Paragraph 4, next page. About 3 lines from the top. It is denied that the plaintiff has possession and cultivation of the scheduled property in the agreement. In fact, for the amount advance as more who in turn has permitted the plaintiff to harvest. Legal notices were exchanged. This is important. legal notice to escape by and between the plaintiff and prosecutor. Defendant number one, where defendant number one called for the plaintiff to render accounts and specify the exact amount payable for the plaintiff to apply the said amount has come up with the bracket of agreement. Second, the defendant who never intended or actually the transaction is not covered. So it is her case that she has issued notice to calling upon me to give accounts. So the amount is admitted that I have paid her. Now, what remains is whether it is a loan transaction or whether it is an agreement. My lords, kindly take paragraph 8 on the right hand side. The defendants have already demanded the plaintiff by way of legal notice for settlement of account specify and arrive at just figures for which defendants are ready and willing to repay just amount. So she is ready to repay and she says she has issued a notice. Those notices have not been released. She only says this remains an averment in the written state. She says she has issued a notice saying that it is a loan transaction and give me accounts, I am ready to pay. I am ready to discharge the loan. Those notices have. On the other hand, I have issued notice.
1 second. From this written statement, one can certainly say that the defendants have never admitted that the transaction is a sale agreement.
They have never admitted. They have set up a plea.
They never said that mother has acted on her behalf, right? That is also true.
They have never accepted that it is a sale transaction. That is absolutely correct. What they have said is
they never say that mother entered on their behalf.
That is what I will come to. What happens is, I have issued a notice to all of them. I issue a notice to all of them. They don't respond to the notice. My notice is there. My notice is there.
You call all of them to
come and execute the sale deed. It is at page 39.
They don't respond.
They don't respond. In fact, she takes an additional advance from me after that. Page 39.
Yes.
Page 39 is my first notice, dated 12/5/1990. Here I call upon them to execute, come and execute. Then exhibit P50, I again call upon them. That is 23/5/1990. Between these two notices, after the first notice is issued, she takes an additional advance. She endorses it on the agreement that she has taken an additional advance. Second notice also, we issue. They don't respond to that. Then we come and file before the trial court. Now, what happens is, what the appellate court has said also is that they are estoppel by conduct. Notices were issued, they did not respond. They file a common written statement. They say it is a loan transaction. And they don't respond. After the notice is issued, she receives another amount and she endorses it on the agreement. And subsequent notice is issued, they don't respond again. So the trial court has held that they are estopped from contending that they are not parties to the agreement and that she has not.
Just a second. You issue a second notice calling upon the defendants to come and execute this sale deed. There is no response to that notice by the defendants. Afterwards, what you have done to change your position or to have some advantage. See, Estoppel is, you know what it is.
I know what.
There must be representation.
There must be representation and I should have changed my position.
You must act upon representation. You must change your position to your advantage. Then only Estoppel comes into picture. Inaction, mere inaction doesn't amount to Estoppel.
They were all doing. There is a very, my learned friend has cited one headline.
No, if the sale deed was executed by the mother.
After issuance of notice.
After issuance of notice.
They did not respond.
Then it amounts to Estoppel as against them. So sale deed is not executed.
True. What I am submitting is not. My first notice I issue. They don't respond. And she comes and says, give me more advance. I have given her more advance. then she doesn't come forward to.
You say that more advance is given by the mother or by you to the mother in the presence of remaining children and they kept quiet.
They kept quiet.
Is it your case?
No, it is not my case that after issuance of notice also, they did not respond.
That is understood. If you are saying that, since they did not respond, they came and demanded money, and I gave money to the mother in the presence of all. Is it your case?
No, it is not.
Then it amounts to Estoppel.
It is not so. It is not so. I will not submit anything wrong that has not been done. It is not so. It is not so. Neither have I stated so in the
No,
pleadings.
if it was done so, then probably that would fit into the definition of
My
Estoppel.
submission, I issue a notice. It is as good as when they are not available for me at one place. I issue a notice to them. The notices have not been denied in the written statement. Now, subsequent to that, she receives amount. I issue another notice. Subsequent to that, she comes and files a written statement. When she files a written statement, they come and adopt the written statement. So they are sailing with the mother. Whether it is a sale transaction or not, whether it is a loan transaction, I will come to it. But they are sailing with the mother. Whatever the mother has done, they have stood by her. So if the mother is bound by the agreement, they are also bound by the agreement. Because they don't say, no, my mother did not have a right. My mother could not have been, she doesn't represent us. Whatever the mother says Pardhanashin lady. Then she says, I have executed the agreement, having received amount.
If she is Pardhanashin lady, what advantage she will have under the law?
There used to be. Today, Pardhanashin lady, there is a judgment 1963 Supreme Court. I will.
Not just wanted to ask.
Earlier, the position was not, there was a defense that Pardhanashin lady, what happens in Muhammadan law is the husband is there. Then if the lady executes any document, then the husband has to give assent to it. If he has not done, then she is considered as a Pardhanashin lady who has acted without knowing the contents. Those defenses, the customary law, those defenses were there. But now it is not. Now, this is the position. My lord, I will connect the dots. My lord, the written statement is there. Now, the written statement, they say that it's a loan transaction. Cannot. My submission is notice has been issued. She received additional advance. Another notice has been issued. Then the suit has been filed. Written statement is filed by her, adopted by them. On the same day, I did not know this. I have come to know about this before this honorable court when my learned friend has filed this judgment. My learned friend has filed a compilation. The Lord should kindly take that compilation.
This one?
Yes. In that compilation, Lord, page 121. Page 121. This is, fortunately for me, this is a judgment of the neighboring land.
Judgment?
Of the neighboring land. Concerning the neighboring land.
Yesterday I mentioned.
This is the judgment of neighboring. These are also undisputed facts. I am not arguing any facts at all. I will not be able to argue any facts. Only putting for the facts. Their contention is that they have not signed the agreement, so they are not bound by it. Now, my lord, this judgment, my lords may kindly say, neighboring land, same day the agreement happens.
This is a different party.
Between their
Neighbors.
maybe some relatives. Because they are also Muhammad.
Similar situation where a document is not signed by all, but signed by only one person.
Yes. So the document is not and they say it was taken, the loan was taken for marriage. So how many marriages were happening? Same defense. The defense is also that Pardhanashin lady. And the defense that was raised before the honorable court, that the sale consideration is inadequate.
Inadequate.
Inadequate. 90,000 ರೂಪಾಯಿಗೆ 10 ಎಕರೆ ಜಮೀನು.
That was not the defense here.
That has not been the defense anywhere. That has not been. In the evidence, she says, 1 lakh rupees. On the date of the agreement, I was told by my.
All right.
It was 1 lakh rupees per acre. Now, in this judgment, my lords may kindly take paragraph 30.
Yes, the instant case.
In the instant case, it has been noticed. Plaintiff claims to have contracted with the defendants to purchase 15 acres of land for a meager sale consideration of 90,983. He has failed to establish why sale price was so marginal and what was the rate per acre. That itself had created a doubt about the transaction being a legal transaction. On evidence, we have seen defendants have successfully established the case of probability that it was a loan transaction and not a transaction of sale. Besides, even if we accept it to be an agreement of sale, then the sale price is at 90,983 for 15 acres of land shows it is inadequate sale.
What is the extent here? What is the extent here?
Same extent. Same.
How much?
Same survey number.
How much amount?
Same amount. Same amount.
So this court has held that the sale consideration is inadequate.
Why this court held that? The representation was made that it is a meager sale consideration. No, my lord, I have filed an application.
And what you are saying is, this court has held that it is a inadequate consideration because there was a defense in that case. No such defense in this case.
No, sir, no. Even if there is a defense, my case is not why this. Now, what happens is here also there is an agreement. It is not that I alone have cheated. According to them, all the people who executed agreements on that day have all cheated the vendors. The same sale consideration is shown. My lords may kindly see whether it is possible.
No, this court has come to the conclusion that rupees 90,983 is inadequate.
Is inadequate. Which is not correct.
To the neighboring land.
For the neighboring land, which is not correct because there was no material available for this honorable court to gauge whether this is adequate or not.
How do you say that this judgment is incorrect?
I have produced, my lord. I have produced, I have made an application number 41 to 27 for additional evidence. I have produced sale deeds of another neighboring land, the same survey number. Sale deeds I have produced, where the sale consideration is less than this. I have produced two sale deeds, not one. I have produced two sale deeds.
Right.
I have produced certified copies of those sale. I was not aware. This my lord, in fact, helps me. That is why I am saying a representation has been made.
So what you are trying to say is the judgment can't be taken as a basis to say that the sale consideration amount is inadequate.
Two things out of this judgment. That is one, what my lord says, that it is not inadequate sale consideration. Secondly, if I were to have made a loan transaction, then I would not have given the correct price in the agreement. Sale deeds are there to prove that a price that was the market value of the property was fixed. In fact, the sale agreement for my lord in this case, the sale consideration is more than those sale deeds. And those sale deeds are subsequent to this agreement. 1990 agreement. Those sale deeds are 92 and 93. I have produced those two sales.
One thing I understood that.
And secondly, my lord, this series of defenses that have been taken, Pardhanashin lady, in all these cases, I am told that there were another one or two cases like this. Same day the agreement has happened, same sale consideration has been fixed. And when the plaintiffs sue, the defense plaintiffs in a specific performance suit will say this is the sale consideration, come and execute the sale. That can be accepted. But for the defenses to be the same, that there is a marriage, so I wanted a loan, that I am a Pardhanashin lady, that this is not a sale transaction, this is a loan transaction. Stereotype defenses have it. So that makes this agreement, this document more probable to be an agreement rather than a loan. It can't be that so many people on the same day at the same time for the same survey number
cannot take loan.
They cannot take loan and cheat so many people at the same time on the same day. ಒಂದು loan transaction ಆಗ್ಬೋದು, ಒಂದು sale transaction ಆಗ್ಬೋದು.
All right, understood. Now,
ಒಂದೇ ದಿನ
now let us
ಅಷ್ಟು
assume,
ಜನನು
so let us assume that you have established that the sale agreement is executed by defendant number 1. How it binds remaining defendants?
Yes. I am relying on agreement. I have already 1979 to page the paragraph 20 and 21. Paragraph 20. The next contention is that here what happened to that? Father tells son's land. Father has sold the land belonging to his son. So whether that is correct or not, whether it binds the son. The next contention is that even when the confers authority on dependent 34 to sell land, the authority conferred on dependent 34 was to act on his own and not on just of an outsider or as a rubber stamp of someone. And that in this case, evidence clearly shows that it was causing your son, the father of the plaintiff, to enter into an agreement, exhibit B 18 dated February 14, 1949, with the defendant 1 for sale of land and the agent defendant 34 merely rubber stamp the sale and executed the sale deed. And that such a thing is not binding on the plaintiff. At first blush, the argument is really attractive, but it does not stand scrutiny. Land involved in the dispute was granted by the Nizam to the father of the plaintiff or the minister in the Nizam government. Patta evidencing the grant was taken in favor of the plaintiff, who was then a minor. The father of the plaintiff really believed that he was the owner of the land, and in fact, on October 20, 1949, he wrote to Tasika that his son was a Dinamida, and that the lands may therefore be transferred in his name. Thus, the father of the plaintiff acted as if he was the owner of the land, but when a contention on behalf of the respondent plaintiff of the Dinamida would be presently examined, it would be pointed out that the plaintiff was the real owner and was not Dinamida. That is the truth in legal position. The fact, however, remains that the father of the plaintiff must be a man of considerable influence. He understood that the government of Nizam must have acted as if he was the owner of the land. Undoubtedly, the agreement exhibit B 18 for the sale of land was entered into between the father of the plaintiff and defendant number 1, and pursuant to the agreement, defendant 34 executed the sale deed in favor of but it may be noticed that agreement exhibit B 18 was entered into 2 months prior to the grant of power. Exhibit B1. There is, however, evidence to show that the agreement of sale of land and the sale deed were taken in presence of and to the knowledge of full acquisition of the plaintiff. Witness.
Just a second. Plaintiff is the son of Nizam, minister?
Yes.
Plaintiff is the son. Who is defendant number 34?
Defendant number 34 is another person who executes the sale deed, claiming to be the GPA holder of the plaintiff.
Son.
Where that has also been denied by the plaintiff. He says, I have not done. So they relied upon the agreement executed by the father of the plaintiff. Father of the plaintiff had executed exhibit P18. That was relied upon, and they said that you are stopped from contending that defendant number 34 of the he could not have entered into. In fact, the extract is that the correct.
No, the evidence is whether the father executed the sale deed in the presence of son. In that case,
Yes.
it's a classic case of Estoppel.
It is not that he executed in.
So that's why I'm asking, is it your case that the agreement was executed in the presence of children?
Was not executed in presence of the children, but the consent was there.
How it is established?
It is established not because 2 notices have been issued. They don't object, and they continue to sail with the mother. They continue to toe the line that the mother has taken in the defense. They adopt the written statement of the mother. So if the mother is found, if the mother has, they don't say that our mother has acted in detriment to our interest. They don't say that. They don't file a separate written statement. They agree that money has been taken. It is their case that it is a loan transaction. And they say that, they further say, that is my next submission. I pointed it out to my lords that they say that it is a loan transaction and we have issued notice to the plaintiff to give accounts, how much we have to pay, and we are ready to pay. So that means that they are all together. Now, if this is an agreement to sell, then they are all together. If it is a loan transaction, they are all together. My submission is, if this honorable court were to
What you are saying is entire consideration amount was paid under the agreement?
entire 53 and or more than half of 50% of the sale consideration.
What is the time stipulated?
There was no time stipulated. There was no, but it is well within time. I have acted. The first agreement is 1990. The second agreement is in 1991. And she goes on taking money up to 1993. The suit is filed in 1994.
First appellate court gives a pending that you are ready and willing.
So, first appellate court says it's a loan transaction.
First appellate court held in your favor.
First appellate court, yes. I was ready and willing, as well as Estoppel, there is an Estoppel against the other defendant. My submission, my lord, my lord's defense is
any issue relating to Estoppel?
No issue has been framed by the trial court regarding Estoppel. But my submission, Lord, is when they say in the written statement that they are ready to pay back the amount, and they issued a notice, they don't produce that. Adverse inference has to, their defense is that it is a loan transaction. Their first act, when I issue a notice for calling upon them to execute a sale deed, they should have written a notice that it's not a sale. They say they have issued a notice. So that notice would obviously say that it is a loan transaction. No such notice has been produced. I have not received any such notice is only stated in the written statement as a defense.
All right, come to again this page which you are reading, page 612, the judgment, Supreme Court judgment. Last 5-6 lines. There is, however, evidence to show that agreement for sale of land and the sale deed were taken in the presence of and to the knowledge of with the full acquiescence of plaintiff.
This is exactly what I am saying. I don't know about the presence. I will not again make any attempt to say that they were present. I am not.
You are attributing knowledge. You are attributing knowledge from the circumstances where you issued 2 notices, and the defense is taken in the written statement by the mother that it's a loan transaction. Same is adopted by them.
Loan transaction, and they say they have issued written a notice to that it is a loan transaction and that they are ready to discharge the loan.
All right. If they don't produce that notice, the adverse inference is that they have not issued that notice.
Adverse inference, not that they have not issued the notice. That is not the adverse inference. When they assert, when they assert that they have issued a notice to me, calling upon me to state what is the account, give me the account that I will pay you the discharge the loan. Then the adverse inference that there was no loan. They have not issued such a notice. They have only set up a defense like that. Adverse inference has to be drawn about the facts that they say.
No, what is your defense to their contention that they have issued a notice? You admit that they have issued a notice?
No, they have not. They have not issued any notice.
So,
in fact, my lord, I have said two. In fact, in the complaint, I have said I have issued 2 notices which they have not replied. There has been no communication. But my submission is.
So understood. I understood your point. What you are trying to say is in your notice you have asserted there is an agreement for sale, and you call upon all the defendants to execute this sale. That is understood. If they don't reply to this notice, does it amount to estoppel? When you have not done anything to show that you have changed your position to your advantage.
But subsequently, I have made payment, additional payment of sale consideration. She takes additional amount from.
Then all right. No, understood. Then you should have made the payment in the presence of all those persons. If it is your evidence that the payment is made in the presence of all those persons, and they acquiesced your act of making payment to her and mother accepting the payment, then it amounts to estoppel.
Inaction. having come to know
If you
that I am
discreetly,
claiming
no,
there is an accident.
no, if you discreetly make payment to the mother, doesn't amount to estoppel.
After issuing notice, they don't reply. It can still be said that no, there is no. But they come forward in the defense and they say, we issued a notice saying that there is a loan. If I were to have
That is disputed by you.
that is disputed by me. That is why.
And they have not produced it. That
They have
means,
not produced it. That is why I said
that means notice is not issued.
that is why they have not issued a notice.
Understood.
So their defense falls that it is a loan transaction. And they
No,
were
understood. That is
and
understood.
they had knowledge of this agreement. And they did not take any further action. That is why they have.
So no action need to be taken because they are not signatories.
But
So what action they could have taken? No, do you expect them to file a suit for cancellation of agreement if they are not signed?
If they were to have kept quiet, saying we are not parties, if they were to have kept quiet, we are not parties to any transaction.
Understood. What you are
But
trying.
they say we have received money.
No, understood.
And it is a loan transaction, and we have sent you a notice.
So that is understood. What you are trying to say is you are trying to bring your case under the doctrine of estoppel. So where is other ingredients of estoppel? That's what I'm asking. Understood your point. There are other ingredients. If you are able to show that subsequent to issuance of notice, first
By
notice,
their inaction,
the payment was made in the presence of remaining children and they kept quiet, then you are right. It is not the evidence.
their knowledge it was done, not in their.
All right, where you have stated so. See, estoppel is a matter of evidence. It can't be presumed. It has to be pleaded and proved.
My submission, my lord's.
You got from my point.
But I
It's
know.
a matter of evidence.
I understand that.
You really made a very interesting point. There is no doubt about it. Yesterday when you made a submission, I thought that is a clear-cut case. You made a very interesting point. But now I'm trying to understand. There is a case of estoppel here when there is no evidence.
Unfortunately for me, at this stage, there is no plea, but evidence is there. And finding is there of the appellate court.
Finding is under challenge.
That is it. Lord, there is a judgment. Lord, I permit me. Tomorrow, my Lord, Monday, my Lord. There is a judgment regarding a sale agreement in such circumstances. Not of Karnataka High Court or some other High Court. I will, under similar circumstances. Lord, if their defense that it is a loan transaction, if they were to simply say we are not party to the agreement, I have. But they go further and say it's a loan transaction.
We'll have it on Monday. We'll have it on Monday. Third Sri, Dr. Mesra. Yeshu Mishra, Learned Counsel appearing for the respondent. Learned Counsel, after arguing for some time, would seek a short accommodation to argue further. This matter on Monday or further hearing. Interesting argument. Yesterday, my impression was I can allow this appeal in 2 minutes. Who is ready? Sorry? Yes.
not responding to that. But I will be taken up on Monday, I will get ready.
Which is this matter? Which is this matter?
Okay. 48.
Universal ಆಗಿತ್ತಾ hearing? Final hearing. ಅವರೆದುರಿಗೆ.
And the next day he spoke, question was whether court can gone into the validity of the order passed for the land tribunal. Then Honorable Justice himself passed a statement saying that in certain circumstances, courts can gone into the validity of the statement.
If the order, if I understand, if the order goes, the question is relating to the jurisdiction of the land tribunal to pass an order.
Statement Monday is in the and next day I came along with the
48 list on Monday.
I will wait on that.
Then I will.
Objection and all.
49.
I filed an application for order 41/27. Already on the application, said it miss out. Give permission to do the additional evidence.
You file an application.
Objection and all.
What is this? You have produced Xerox copy. Where is the original? Huh?
What is it?
You have to produce the original. Additional evidence. This is not writ petition.
Objection and all.
You produce original also. He is going to produce original. Already filed. The consider for the appellant has filed application under. ಇದು ಬೇರೆ ಮತ್ತೊಂದ ಇದು on 2 of 2007 ಏನದು?
Additional evidence. Certain document, main document miss out.
1 of 22 na. Consider for the appellant has produced I number 1 of 2022 seeking production of additional evidence. Then consider for the respondent seeks short accommodation to file the statement of objection. List this matter after 2 weeks. So along with the number. This is for admission. Where is he? You served him the copy. Weeks time granted. 21 weeks time granted to the request. 40.
They claim that they are the owners of site number 20. We are the owners of site number 24. The only claim is that instead of constructing site number 24, they have constructed the building inside. I'm ready. Request to lordship. Exhibit D1.
Good. Two 202. Yes.
I am the one of the.
So what he is trying to say is, one more site is formed in the area earmarked for drainage. So because of this, the site number is changed.
Because after site number 24, there is vacant space. It's unnumbered site.
After site number
24 towards the western side.
Where do you get site number 24?
Third line.
This one. 23. Top one is 24. You have purchased 24.
I purchased site number 24. Line T plus purchase site number 23. The title has been approved by both of them. We are the owner of site number 24 and they are the owner of site number. The only question is whether defendant, that is owner of site number 24, has put up construction in site number
23.
That's it. And apart from that, the defendant has constructed a building in the year 1979 itself. Same came to be challenged in the year 1987, the mandatory zone. After a lapse of 8 years. These two issues have been framed. And
you constructed in 1979.
Yes, sir.
That is established.
That has been established.
You admit that you constructed 1979.
And it was a cross examination.
All right, now site number 24 is vacant now.
Site number
DW want to put up construction site.
DW?
DW one who purchases site number, joining site of site number 24.
It is site number 25.
25 comes to the right. 24
ಇಲ್ಲಿ
open space.
Open space.
That person put up construction in this.
No site is vacant now.
Ask him about site number 1, which DW1 has purchased is vacant. DW1 has put up construction in itself. That should be vacant. Instead, those are not vacant. That will take something.
Fact is that defendant has put up construction in the site number 24. After site number 24, it was that unnumbered site. Earlier, the person who had found the layout had retained the set unnumbered space and subsequently has sold the unnumbered set in favor of DW1, who has been examined as DW1. He states that he is the owner of unnumbered site after his site is coming up towards the western side of the site number 24. So there is no such vacant land available. After 24, there is unnumbered site.
Now you admit that you have purchased in site, constructed in site number 23.
No.
You don't admit.
You have constructed a site, building in site number 24.
The first couple of reports you have constructed in site number 23.
Yes, sir.
And that is the finding.
That is the finding. But the trial court has held that we have put up construction in the site number 24 itself. Even the commissioner reports states so.
All right. So the commission. The case is revolving on the commission's report, right?
Even there are some admissions, madam. These were not ಅನ್ನತ್ರನೂ ಇಲ್ಲ ಕೇಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಾ ಅಂದ್ರೆ
ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ It is not a case where vendor has sold the same site to two persons. Something like that. Case of mistaken identity at the most.
What has happened is site number 16 may not to the eastern side of the layout. This will not shift to exhibit. Where is the exhibit D1? In the site number 16. There is some time of the plaintiff was that there is some vacant site which has been found in the site number 16. It's a case of lateral shift. Site number 16 alone. There is no such vacant site. 16 16 ಅವರು encroach ಮಾಡಿದ್ದಾರೆ and the landlord has been.
You do one thing, you go through the papers. Afternoon, I have got one small matter in the division bench. Muskon Bertini, probably 2:45 I'll be here. In the meantime, you can go through the papers, go through the sketch offs. We'll finish off this matter. He says he has not seen this sketch. You can go through that.
Hello. Total, sir. Hello, Kotal, sir. Sir, Kotal sound ಬರ್ತಿಲ್ಲ, sir. Sound on ಮಾಡಿ. Hello, Kotal, sir. Sound ಬರ್ತಿಲ್ಲ, sir. Kotal ಇಂದು. Sound on ಮಾಡಿ.
Appellant to pay the process fee within 3 days. Registry to issue notice. So respond number 1A.
A. Venkatesh.
Good evening. Then appeared for the appellant in the morning session. No representation in the afternoon session as well. The suit for partition is decreed by the trial court. The appeal against said decree, the challenge against the said decree was unsuccessful, and the appeal is also dismissed. The defendant is in second appeal. The appeal against respond number 1 is dismissed as abated. Dismissed for dismissal. On 5th December. The 23rd November. 22nd November.
O. Mahesh. 39 O. Mahesh.
Next is there.
Okay.
Just have you gone through this sketch? What does it indicate? The commissioner is appointed at whose instance? Does allow. There are 2 sketches, 2 reports. Exhibit C7. Is there an objection to this report? Do not filed objection. So this report says what?
I will request your lordship to see exhibit D1 along with the commissioner report.
D1. What is
Slide number 24. The ninth side. The 16, 17, 18, 19, 20, 21, stretch. There are 9 sides which has been found.
Yes, 24 is the 9th site.
Yes, sir. Dependent side is the side number 24 is the 9th side. According to the commissioner report also, It's a 9 section.
Excluding the site formed on Nala drainage, excluding that.
ಮನೆ ಅಂತ ಒಂದು ಹಾಕಿದ್ದಾರೆ.
Yes, Prativadiya Mane. Yes. Then next is foundation.
Next is foundation. This is unnumbered segment, which has been claimed by DW1.
So what the commissioner says, the next two plaintiffs' defendant site is Khali Jaga. This is what the report says. 8, site number 8.
That is site number 22 according to us. That is, if we take into account this first site which measures 23 feet by 40 feet. Just next to the drainage, there is a triangular site also situated. 23 feet by 40 feet.
Yes.
The next remaining sites are 30 by 40 feet, evenly divided.
All right.
Question is whether this site.
What you want to say is that site measuring 23 into 40 is to be excluded.
Yes.
Now who is in possession of that? Owner.
This site is not part of the property.
This site and
Because of this, the first appellate court says that he has constructed in your flat.
Next to that site which they claim to be theirs, there's one shown as B.N. Nadigar's house to the top. Prativadigal main house. He's examined as He's one of site number 26. His debit is produced as exhibit B.
Where is site number 26?
26 is 202. Just beyond 23 years. Other boundary my side is shown as site number 26. That is accepted that his house it becomes site number.
So in that event, he doesn't own site number 24.
He has permitted the DW1 to construct in site number 20. DW1 is the purchase of the unmarked site next to the site number 20. And I examined his vendor also. Who comes and says that this is not.
What is the remedy for you now?
Because they contented word here in the process in the first one is the issue. He says that in 1981 he constructed.
Suit is filed in which year? 87.
I can tell you this. I don't decide. Just like just
All right. According to you, when the construction took place? On evidence.
On the cross examination, my oral statement is not wrong. DW1 on confirming basis. You have cross examined.
No. Is there anything on record to show that this building was constructed in 1979?
In the construction.
No evidence.
Because in the evidence it says it completed the construction in 1979. The declared only is building was constructed in 1981 and the assessment was made in the 1982.
All right. Is there any document to show that assessment made in 1982?
taxpayer building construction.
Did you obtain permission?
Yes, sir. I have obtained the permission.
When the building number was assigned?
1979. Permission has been obtained.
When the building number was assigned?
1988.
Document is produced? Even if it is 1982, then also suit is brought back. Suit for possession? Possession.
There's not a mandatory possession.
Read the prayer. For vacant possession, yes. Assuming that the decree for mandatory prayer for mandatory nation is barred by time. Decree for possession would lie.
My submission is that and constructed a building in site number 24 itself, because according to the commissioner report itself, because we need to, revenue layout has been accepted, the sketch has been accepted. After the drainage,
Just a second. The appeal is dismissed on which ground? Only on limitation?
Prayer of possession and mandate alienation is that is substantial question of law is the court whether when declaration is negative and the decision is rejected.
How do you say the suit is?
the High Court came to the conclusion that I put up construction in site number 24 itself. With respect to the said issue, it was been answered in favor of.
That is challenged. The finding is challenged.
The finding was been challenged.
No, you are not filing to challenge the finding of the first appeal. The order 41 rule 22 you are saying.
When then there is no cross-examination.
Understood.
Cross objection to the said.
Understood. That's
With respect to the said
understood.
issue.
Now you have to establish.
No, I need to establish.
All right. I'll permit you to argue, but you have to establish that the property belongs to you.
It has been accepted by them that I am the owner of site number 24. The chief examination itself is.
No, that is understood. The question is whether the property on which you have built the house is site number 24. That is the question.
Yes. So, one more solution is that exhibit D1 is accepted. That is the layout sketch. After the drainage, there is site number 16.
After drainage?
There is site number 16. Other exhibit P series and yellow flag active. It will be easy for you not to have paper book.
D1 alwa? D1. Third row, understood. There is a corner, there is a triangle. In the corner, there is a triangle.
Yeah. Other Pankaj 16.
16, huh?
Yes.
Adjacent to Nala.
Adjacent to drainage, there is site number 16. Then 17, 18, 19, 20, 21, 22, 23. And 9 site is site number 24, which has been claimed by the defendant. Now, I request you, Lord, Commissioner.
Now, what you are saying is you are constructed in site number 24.
24, that is the 9 site. Even the Commissioner report.
Now, how do you say that this report is established? This exhibit D1 is established?
They admit, madam.
This is an admitted document. So now if this is admitted, he has constructed in site number 9. That belongs to him.
After this site number 23 by 40.
Understood.
There's one dotted line may not see. One chick dotted line cut ಮಾಡಿದ್ದಾರೆ. ಮೇಲಕ್ಕೆ. That is the area which is yours.
What may take completely
So this is the area where layout is formed. What about these sites?
This only the survey is only with respect to that plot. 16 to 24 survey matter.
No, right. What you are saying is the sites which are shown by the commissioner in his sketch, they are not part of layout.
They are part of layout. What is only consider layout?
Understood.
Now let me see cross examination. Argumentation is yes. They are here.
All right. Commission report. Yes.
That is the D1 sketch.
There are 2 dotted lines. One left side and one the right left.
Yeah. So argumentation is so the side of there are no parts. So this nothing is cross examination. That is size measured 30 by 4. This point not to find page 159 of the paper.
You admit that he purchased site number 8.
In my side, it is not a side number 23.
All right, 23, but in its sketch it is number 8. It is his property. You admit that? 159, yes. Where do you get it? Where do you get it? Ah, Badawani, yes.
And in that case is that the question of 93/40 not all within the beyond this the witness which is process.
Which?
157.
Yes.
ಒಂದು ತ್ರಿಕೋನ ಮನೆ ಮತ್ತು ಖಾಲಿ ಜಾಗ ಇರುತ್ತದೆ ಅಂದರೆ ಸರಿ. ಅದರ ನಂತರ ಒಂದು ತ್ರಿಕೋನದ ಮನೆ ಮತ್ತು ಖಾಲಿ ಜಾಗ ಇದೆ ಅಂದರೆ ಸರಿ. ಆ ಖಾಲಿ ಜಾಗ ವಿಸ್ತೀರ್ಣ ಪೂರ್ವ ಪಶ್ಚಿಮ 20 ಅಡಿ ಮತ್ತು ಉತ್ತರ ದಕ್ಷಿಣ 10 ಅಡಿ ಇದೆ. ಇದು ಸರಿಯಲ್ಲ. ತ್ರಿಕೋನಾಕಾರದ ಅಂಚಿನ ಮನೆಯಲ್ಲಿ ಬಡಾವಣೆಯಲ್ಲಿ ಮೂಲ ಮಾಲೀಕರಾದ ವಾಸವಿದ್ದಾರೆ ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಅವರು ತ್ರಿಕೋನಾಕಾರದ ಮನೆ ಮತ್ತು ಖಾಲಿ ಜಾಗ ಸೇರಿಸುವ ಅರ್ಧಗೊಂಡಿ ಜಾಗದಲ್ಲಿ ಶೇಖ್ ಮೊಹಮ್ಮದ್ ಶರೀಫ್ ಅವರಿಗೆ ಮಾಟ ಮಾಡಿದ್ದಾರೆ. ಆ ತ್ರಿಕೋನಾಕಾರದ ಮನೆ ಬಡಾವಣೆಗೆ ಸೇರಿ ಅವರ ನೆಕ್ಸ್ಟ್ ಬಡಾವಣೆಯಲ್ಲಿ ಮಾಡುವ ಮುಂಚೆ ಈ ಬಗ್ಗೆ ಚರಂಡಿ ಬದಲು ಒಂದು ಅಲ್ಲ ಸರಿ. ಮುನ್ಸಿಪಾಲಿಟಿಯವರು ಹಣದ ಚರಂಡಿ ಮಾಡಿದ ನಂತರ ಸಾಕಷ್ಟು ಜಾಗ ಉಳಿದಿದ್ದು ಅದರಲ್ಲಿ ತ್ರಿಕೋನಾಕಾರದ ಮನೆ ಮತ್ತು ಖಾಲಿ ಜಾಗ ಉಳಿದಿದೆ. open drain and that gets shifted. And the other point is not misstated. Eastern boundary is on a site number 25.
Sorry?
Eastern boundary.
In the plane?
It's stated. It's stated and the stated. Eastern boundary is on a site number 25. And this state you do not clear any site number.
Just a second. In your he said it, the eastern boundary shown as site number. Yours is 23, right? Oh.
Should come. My site shown as site number 25. This is purchase from the hotel land. The direct purchase. All this said it, there is no mention of site number and this eastern boundary is.
In all his said it, there is no reference to.
Even in written statement, it does not say which is.
Even in your said it also.
My said it site number 23.
So in all the parents said it, there is no reference.
So there is a reference. Now this statement is it B6, B7, B8, B9, B10.
Now, who assigned these site numbers? Vendor. That is exhibit D1.
Is 213. There is a reference. The first side. When the developers and executive say, the next slide, schedule. Then again,
All right, this is sale dated.
29/9/1962. And exhibit
So when you purchase,
When
all right, now look at the boundary. Look at the boundary. Purvake 25. 22 ಆಗಬೇಕಲ್ವಾ ನಿಮ್ಮ ಪ್ರಕಾರ ಅದು? 23 ಆಗುತ್ತೆ.
But my lord, I request you not to keep placing 100 of the chief of the plaintiff himself.
No, just a second. When you purchase the property?
He purchased it on
Plaintiff.
26/10/1960.
26/10? No, he purchased in 1960. He is vendor, he is vendor.
29 is 1926.
So if his vendor has purchased site number 24, he could not have purchased. So when you admit exhibit D1, how can you lay claim over price number 23? Now, how can you lay claim over site number 23? See, exhibit D1 is admitted. Under exhibit D1, you claim to have purchased site number 24. Now the suit is filed in respect of site number 23. Then
I claim site number 24 itself. I claim
the suit is filed in 23.
He claims site number 23. But what he states that is, instead of constructing site number 24, I have constructed in this property.
Yes. Yes. So that is established.
Your first position is also taken into consideration.
No, that is established in the survey sketch.
According to the survey sketch itself, according to the D1 and survey sketch, mine should be the 9th site. I'm in the 9th site according to commissioner report as well as.
No, commission report takes into account one more site which was not in the layout. There is a admission in the cross examination.
I should not see. There was a last of the site number 16. There was a triangle of respect to the same. The admission was given. Otherwise, sketch last on 20.
In addition to that, he also makes a reference to site measuring 23 into 40. There is an admission in the cross examination. See, in addition to triangular site and triangular house, whatever, he also makes a reference to site measuring 40 into 23. He says that site was not in existence when the layout was formed. That is the admission. This is not straight admission. Another reason is, he further says, all sites were measuring 13 to 40 and all sites were facing particular direction.
The triangular house which is made by the landlord, they have enclosed with the site number 16. Other than the site number 16, that was the finding given with the trial court. Site number 16.
Now, one thing is understood. Exhibit D1 is an admitted document.
Yes, sir.
Site number 8 in exhibit D1 belongs to him. Site number 9 belongs to him. So you have constructed a house under the impression that it is site number 9. He says it is site number 8. So that is to be identified by the surveyor. Surveyor says it is site number 8. No. He says though it is site number 9, this is not site number 9 as shown in exhibit D1. This is site number 8 as shown in exhibit D1. So by the time survey was conducted, one more site was added. One more site was added.
Drainage change because as per exhibit D1 itself, drainage.
Now, how do you explain that all the sites were 13 to 40? Clear cut admission. And how do you explain that there was no site measuring 14 to 23? Clear cut admission.
Because it's a revenue site. Revenue layout because hand sketch
Understood. So from the evidence on record, since exhibit D1 is admitted, one thing we can certainly say that site number 8 belongs to him, site number 9 belongs to you. Right? The next point is whether you constructed in site number 9 or site number 8. According to this sketch, it appears that you are constructed in site number 9 in the first instance. But the sketch has to be read along with exhibit D1. In exhibit D1, you don't find any site measuring 23 into 40. Right? In exhibit D1, all sites are measuring same. So to that effect, there is admission in the cross-examination. So that corroborates.
Substitution is that this 23 to 30 feet and 30. It's a drainage is formed. It has been reduced like this. Because it's a revenue layout and a handwritten sketch. 6-7 feet of difference is done there. And there must have been encroachment by the original landlord himself.
Where?
The triangular house at the last one, Mane and the commissioner report. Could have been encroachment.
So in exhibit D1 also you find one the triangular shaped
Yes,
site.
yes, that is the reason.
On the corner.
Yes.
On the
That is
corner.
a triangular house in the corner. ಹಂಗಿರ್ಬೇಕಾದ್ರೆ ಸೈಟ್ ನಂಬರ್ 16 ಅಲ್ಲಿ ಇದೆ, ಅದು ಪಕ್ಕನೆ ಸೈಟ್ ನಂಬರ್ 16 ಬರುತ್ತೆ. ದಟ್ ಈಸ್ ದ ಸೈಟ್. ಫ್ರಮ್ ದೇರ್ 9th site is my site. ಈಗ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ if you verify with the commissioner report.
ದಾವಣಗೆರೆಯಲ್ಲಿ ಮಾಡುವ ಮುಂಚೆ ಮುನ್ಸಿಪಾಲಿಟಿ ಅವರು ಆ ಹಳ್ಳದಲ್ಲಿ ಗಂಡಿ ಮಾಡಿದ್ದಾರೆ. ಇದರಲ್ಲಿ ತ್ರಿಕೋಣಾಕಾರದ ಮನೆ ಮತ್ತು ಖಾಲಿ ಜಾಗ
triangular shape site is already there here. If that is counted, it becomes yours becomes 9, his becomes 10. General area there.
DW1 is in there. D1 allo, D1 sketch allo. The last triangular house ಇದೆ.
ನೋಡ್ದನ?
ಇದರಲ್ಲೂ ಹಂಗೆ ಬರ್ತಾರೆ.
So in between the
ಖಾಲಿ ಜಾಗ ಅವ್ರು ಕೇಳ್ತಾ ಇರೋದು apart from the layout ಅಂತ ಹೇಳ್ತಾರೆ. Does not make any because
no, that is weak community. 23 into 40.
it's a case of lateral ಯಾಕಂದ್ರೆ triangular house ಕಟ್ಕೊಂಡಿದ್ದಾರೆ. That was been retained by the landlord. ಅವ್ರ ಪ್ರಕಾರ ಒಂದು 10 feet ಏನೋ 5 feet or 6 feet encroach ಆಗಿದೆ. That was been held by the trial court also. Encroach ಆದ್ಮೇಲೆ ಸೈಟ್ ನಂಬರ್ 16 ಮೆಜರ್ಮೆಂಟ್ it would have been decreased.
ಈಗ ಕಮಿಷನ್ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಒಂದು ಖಾಲಿ ಜಾಗ ಅಂತ ತೋರಿಸ್ತಾ ಇದಾರಲ್ಲ, that becomes
ಸೈಟ್ ನಂಬರ್ 16
ಅಲ್ಲ 8 including the 23 into 40 count ಮಾಡಿದ್ರೆ PW4 according to your exhibit D1 it is site number 7. Seventh site.
and it says planning site is
No, he has to say so, otherwise he would lose the site.
He examined the PW2. He is on site number 26. As per the legal sketch, site number 23 made 23 under 24. 26. The non-site opposite 26 proper. And we district as denied the Karnataka house. And they are not of site number that.
In fact, my lord, site number 22 owner has enclosed site number.
Is it to scale based on scale exhibit D1? They are not mentioned any scale there. Are you sure? ನೋಡಿ scale ಕಾಣ್ತಾ ಇದೆ ಇಲ್ಲಿ. There is some endorsement in the bottom.
It's a rough sketch, but there's no sketch.
The commercial points of a property. The boundary of the action.
In fact, site number 22 owner has encroached on site number 23 belonging to the plaintiff.
All right, now let us do one thing. Exhibit D1, it is the sketch prepared by the vendor, right? Your vendor or a vendor's vendor, whatever, original owner. Look at the size of the site, all are equal. Then how this 23 into 40 has come into picture?
They need to answer because
so they have tried to answer that because they say that the width of the drainage was reduced, so one more site is formed, and that is admitted by you.
That has not been because of with respect to the triangle.
Here, read out the cross examination. Squarely admitted. Their contention is accepted.
Because we lordship to the cross examination of PW1, he admits certain facts. Chief examination.
You made an attempt to solve the dispute. He's ready.
The area option of 5 kilometers radius.
Allah, this is 2006 matter. There is no further adjournment. There is no point. Yes.
1979, they have taken permission and he has constructed a housing. From 1979. He built a suit after 8
One thing is certain, sir. He is also under mistaken impression. He has constructed. There is no malafide intention.
I have crossed now. Learning, I can do that. Learning, I can do this now. Find something. This will be called. I have 6 months. 2006 to 2012. In doing this. And here, gave it 3 set out. One was 25 kilometers away. 50 kilometers away. I convinced my client for 5 years. He also passed.
Most is invested. For critical 3-floor house.
Yaru.
Dependent.
3 crore house.
3 floors house.
3 floor.
56 lakhs investment.
2 bedroom, 1 bedroom, and 1 farmhouse.
The funny aspect is that he has also lost his sight.
He gets DW put up consider. After this suit is filed, he gets DW purchase the property and consent. So was filed in there 87.
Site number 10, Adu.
95 only make sure DW purchase it. Put up on the 10 consent.
Yes, which one evidence you want?
The positions of DW.
Page number.
Last September 22 Shimalaya Shimalaya
This is cross examination of PW1.
This is the chief examination. ಪ್ರತಿವಾದಿಗೆ ಸೇರಿದ್ದು. It means that I am the owner of site. ಸದರಿ ಸೈಟ್ ನಲ್ಲಿ ಪ್ರತಿವಾದಿಯ ಬೇಸಿಗೆಯಲ್ಲಿ ಬಾಯ ತೆಗೆದಿದ್ದಾರೆ. ಪ್ರತಿವಾದಿಯ ದಯಪತ್ರದಲ್ಲಿ ಪೂರ್ವಕ್ಕೆ 25ನೇ ಸೈಟ್ ಇದೆ ಅಂತ ನಮೂದಿಸಲಾಗಿದೆ. ಆದರೆ 23 ಸೈಟ್ ನಮೂದಾಗಬೇಕಾಗಿದೆ. So it admits with respect to the boundaries also. So insofar as I am the owner of site number 24 is concerned, the defendant, the plaintiff himself admitted. Now with respect to cross examination, page 127. ಈಗಲೂ ಇದೆ ದಾವಾಸ್ ಮತ್ತು ಮನೆಗೆ ದಕ್ಷಿಣಕ್ಕೆ ರಸ್ತೆ ಇದೆ, ಅದರ ಉತ್ತರಕ್ಕೆ ಆ ಮೊದಲನೇ ಮನೆ ಆದ ಮೇಲೆ 3 ನಿವೇಶನ ಖಾಲಿ ಇದೆ. Is the triangular house as per the commissioner report also.
ಮೊದಲನೇ ಮನೆ ಆದ ನಂತರ 3 ನಿವೇಶನ ಖಾಲಿ ಇದೆ.
17, 18, 19
4 ಖಾಲಿ ಇದೆ. 123 into 40 is also vacant. Then khali jaga. There are 330 into 40 sites. They are all vacant. Yeah, if you refer to the sketch prepared by the surveyor, right? D1 prakara 16, 17, 18. D1 prakara. All right.
After triangular. ಸಾಕ್ಷಿ ಹೇಳಿದ್ದಾರೆ 22 ನಿವೇಶನ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ ಸಾಕ್ಷಿ ಹೇಳಿದ್ದಾರೆ, ಬಾಯ ಹಾಕಿದ್ದಾರೆ. 23ನೇ ನಿವೇಶನ ಖಾಲಿ ಇದೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ, ಅದರಲ್ಲಿ ಮನೆ ಇದೆ ಅಂತ ಸಾಕ್ಷಿ ಹೇಳುತ್ತಾರೆ. 24 ನಿವೇಶನದಲ್ಲಿ ಮನೆ ಇದೆ ಅಂದ್ರೆ ಇಲ್ಲವೆಂದು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಾರೆ. ಯಾವ ಸುತ್ತಿನ ಪಶ್ಚಿಮಕ್ಕೆ ಒಬ್ಬರು ಅಡಿ ಪಾಯ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರೆ ಸರಿ, ಅದನ್ನು ಪ್ರತಿವಾದಿ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ಪ್ರತಿವಾದಿ 24ನೇ ಸೀಟ್ನಲ್ಲಿ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ, 23ರಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರೆ. ಯಾವ ನಿವೇಶನ ಪಶ್ಚಿಮ 24ನೇ ನಿವೇಶನ ಆದ ಮೇಲೆ ಸ್ವಲ್ಪ ಉಳಿಕೆ ಜಾಗ ಇರುತ್ತೆ, ಅದು ಪಶ್ಚಿಮಕ್ಕೆ ಒಂದು ರಸ್ತೆ ಇದೆ. ಸೈಟ್ ನಂಬರ್ 24
ದಾವಾ ನಿವೇಶನದ ಪಶ್ಚಿಮಕ್ಕೆ 24 ನಿವೇಶನ ಆದ ಮೇಲೆ ಸ್ವಲ್ಪ
ನಿವೇಶನ ಆದ ಮೇಲೆ ಸೈಟ್ ನಂಬರ್ 24 which has been claimed by the defendant ಆದ ಮೇಲೆ ಸ್ವಲ್ಪ ಉಳಿಕೆ ಜಾಗ ಇತ್ತು, ಅದರ ಪಶ್ಚಿಮಕ್ಕೆ ಒಂದು ರಸ್ತೆ ಇದೆ. which has been claimed by the DW1.
No, see, ದಾವಾ ನಿವೇಶನ ಪಶ್ಚಿಮಕ್ಕೆ 24 ನಿವೇಶನ ಆದ ಮೇಲೆ ಸ್ವಲ್ಪ ಉಳಿಕೆ ಜಾಗದ ಪಶ್ಚಿಮಕ್ಕೆ ರಸ್ತೆ ಇದೆ. 24ಕ್ಕೆ ಖಾಲಿ ಜಾಗ.
24 ಆದ್ಮೇಲೆ.
ಕರೆಕ್ಟ್. ಅದಾದ ನಂತರ.
That is the vacant space is claimed by DW1. I confirm. ಇದೇ ನಮ್ಮ ನಿವೇಶನ ಉತ್ತರಕ್ಕೆ ಕನ್ಸರ್ವೆನ್ಸಿ ರಸ್ತೆ ಕಳೆದ ಮೇಲೆ ಇನ್ನೊಂದು ಸಾಲು ಮರಗಳು ಅಂದರೆ ಸರಿ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ ಸಚಿವರಾಗಿ ಹಾಜರುಪಡಿಸಿದ್ದಾರೆ ರಾಯಪತ್ರದಲ್ಲಿ ಪೂರ್ವಕ್ಕೆ ಚಿಕ್ಕಬಂದಿಯಲ್ಲಿ 23 ನಮ್ಮ ನಿವೇಶನ ಆಗಿದ್ದು 25ನೇ ನಿವೇಶನ ತಪ್ಪಾಗಿದೆ. ಸರಿ, ದಯವಿಟ್ಟು ಎಷ್ಟು ನಿವೇಶನ ತಂದಿದ್ದಾರೆ ನಾನು ನಾಗವಲ್ಲಿಯಲ್ಲಿ ವಾಸ ಇದ್ದು ವರ್ಷದಲ್ಲಿ ಒಂದೆರಡು ಬಾರಿ ಬಂದು ನಮ್ಮ ನಿವೇಶನ ನೋಡಿಕೊಂಡು ಹೋಗಿದ್ದೆ. States that every twice in a year he visits the social property. I can ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂದ್ರೆ I constructed the house in the property in 1979 itself. If that is so, it would have been objected. And admits that I have constructed the building in the schedule site number 24 in the year 1979 itself.
No, that is established. Now, assuming that you constructed in 1979, question is whether the suit for possession based on title.
Execution is that because in the construction not found under the cause of action cleared according to the 1986 line. There's filed a suit in the 1987. The cause of action they state that 1 year back he has put up a construction.
Well, let us assume that you are in a position to establish that the construction took place in 1979. And also what happens?
There is a false cause of action.
No?
What they have treated is
that is too technical. Only see, in a case like this, what is to be seen is whether he is the owner or not. Owner of the property or not. If he is owner of the property, then the question is whether you have perfected adverse possession.
Adverse possession, I do agree.
If adverse possession is not perfected, then his title is still there. As long as title is there, then he can file a suit for possession. Article 65. Yes.
ಮಾಲೀಕರು ನೋಡ್ತಾರೆ ಎಂಬುದಕ್ಕೆ 29/1962 ನಿವೇಶನ ಮಾಲೀಕರು. Next page, page number 130.
Page number? No. ನನ್ನ ನಿವೇಶನದ ಉತ್ತರಕ್ಕೆ ನೇರದಲ್ಲಿ 26 ನಿವೇಶ ಇದೆ. ಅದರಲ್ಲಿ 6 ನಾಡಿಗರ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ. ಈ ಸೇಸ್ ನನ್ನ ಮನೆ ಉತ್ತರಕ್ಕೆ ನನ್ನ ನಿವೇಶನ. No, this is your statement. All right. This is your.
On this side, it is the building is constructed. All Nadigas also situated in.
Is he admitting this fact? No. No. This is your statement in his cross-examination. You can't take much shelter under this statement because it is your statement in his cross-examination.
Next paragraph, page 130. ಒಂದರಲ್ಲಿರುವ 14ನೇ ನಂಬರಿನ ಸೈಟ್ ಜಮೀನಿನ ಮೂಲ ಮಾಲೀಕರನ್ನು ಮೊಹಮ್ಮದ್ ಅಯಾಸ್ ಎನ್ನುವರು ತಿಳಿದುಕೊಂಡಿದ್ದಾರೆ. ಅದನ್ನು ಅವರು 1982ರಲ್ಲಿ ತಿಳಿದುಕೊಂಡಿದ್ದಾರೆ. ಅದನ್ನು ಗುರುತಿಸುವಾಗ ಅವರು ತಕರಾರಿನೊಂದಿಗೆ ಸದರಿ ದಾಖಲೆಯನ್ನು ಗುರುತಿಸುವುದಕ್ಕೆ ಅನುಮತಿ ಕೊಡಲಾಯಿತು. ಅದನ್ನು ವಿಚಾರಣೆಗೆ 15ರಲ್ಲಿ ಗುರುತಿಸಿತು. ಸದರಿ ನಿವೇಶನ ಪೂರ್ವಕ್ಕೆ ಅಳ್ಳಾಯಿತು. Just voted. This is with respect to section 16.
This is the first site, right?
ಸದರಿ ನಿವೇಶನ ಪೂರ್ವಕ್ಕೆ ಹಳ್ಳ ಇತ್ತು. ಆ ಹಳ್ಳದ ಪಕ್ಕದಲ್ಲಿ ಈಗ ಮುನ್ಸಿಪಾಲಿಟಿ ಚರಂಡಿ ಮಾಡಿದ್ದಾರೆ. 16 ನಿವೇಶನ ಪೂರ್ವಕ್ಕೆ ಚರಂಡಿ ಕಟ್ಟಿದ ಮೇಲೆ ಹಳ್ಳದ ಉಳಿಕೆ ಜಾಗ ಜಮೀನಿದೆ. ಅದು ಸುಮಾರು ಅರ್ಧ ಗಂಟೆ ಇದೆ. ಓನ್ಲಿ ಹಾಫ್ ಉಳಿಕೆ ಜಮೀನು ತ್ರಿಕೋನಾಕಾರದಲ್ಲಿದೆ. ಮೂಲ ಮಾಲೀಕರ ನಿವೇಶನದ ತ್ರಿಕೋನಾಕಾರದ ಜಮೀನಿನಲ್ಲಿ ಅಂಚಿನ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ. ಸದರಿ ಮನೆಯನ್ನು ಶೇಖ್ ಮೊಹಮ್ಮದ್ ಶರೀಫ್ ಮಾರಿದ್ದಾರೆ.
So excess land available is only half Muntas. That's what you are saying.
After site number 60.
After site number 60. That is in addition to triangular shaped site. In addition. How do you say?
ಅದನ್ನು ನಿಶಾನೆ ಗುರುತಿಸಿದೆ. ಸದರಿ ನಿವೇಶನದ ಪೂರ್ವಕ್ಕೆ ಹಳ್ಳ ಇತ್ತು. ಆ ಹಳ್ಳದ ಪಕ್ಕದಲ್ಲಿ ಈಗ ಮಾಡಿದ್ದಾರೆ. 14 ನಿವೇಶನದ ಪೂರ್ವಕ್ಕೆ ಜಮೀನು ಕಟ್ಟಿದ ಮೇಲೆ ಹಳ್ಳದ ಉಳಿಕೆ ಜಮೀನು ಇದೆ. ಅದು ಸುಮಾರು 10 ಗುಂಟೆ ಇದೆ. ಸದರಿ ಉಳಿಕೆ ಜಮೀನು ತ್ರಿಕೋನಾಕಾರದಲ್ಲಿದೆ. Own admission. The triangular house has been constructed in the half gunta land. So it is to the east of the site number 16. Then where comes the excess site?
23 to 40.
23 to 40 feet excess site and that. He himself admits.
Then
ಅಂಚಿನ ಮನೆ ಕಟ್ಟಿಕೊಂಡಿದ್ದಾರೆ. ಸದರಿ ಮನೆಯನ್ನು ಶೇಖ್ ಮೊಹಮ್ಮದ್ ಶರೀಫ್ ಎಂಬುವರಿಗೆ ಮಾರಿದ್ದಾರೆ. ಸದರಿ ಅಂಚಿನ ಮನೆ 2 ಚದರದಷ್ಟಿದೆ. ತ್ರಿಕೋನಾಕಾರದ ಜಾಗ ದಕ್ಷಿಣದ ಬದಿಯಲ್ಲಿ ಪೂರ್ವ ಪಶ್ಚಿಮವಾಗಿ 24 ಅಡಿ ಇದೆ. ಉತ್ತರ ತುದಿಯಲ್ಲಿ ಏನು ಜಾಗ ಇಲ್ಲ. ಸದರಿ ತ್ರಿಕೋನಾಕಾರದ ಮನೆ ಲೇಔಟ್ ಮಾಡಿರುವ ನಿವೇಶನಗಳಿಗೆ ಸೇರುವುದಿಲ್ಲ. ಈ ತ್ರಿಕೋನಾಕಾರದ ಲೇಔಟ್ ಮಾಡಿರುವ ನಿವೇಶನಗಳಿಗೆ ಸೇರಿರುವುದಿಲ್ಲ. ಈ ತ್ರಿಕೋನಾಕಾರದ ಮನೆಯ ಕ್ರಯ ಪ್ರಸ್ತಾವವನ್ನು ಅಂದರೆ ಗುರುತಿತ ನಗರವನ್ನು ಹಾಜರುಪಡಿಸುತ್ತದೆ. ಅದನ್ನು ಗುರುತಿಸ ತಕರಾರು ಎತ್ತಿದ್ದರೆ ನಿಶಾನೆ P16 ಎಂದು ಗುರುತಿಸಿದೆ. ಸದರಿ ತ್ರಿಕೋನಾಕಾರ ನಿವೇಶನ ಪಕ್ಕದಲ್ಲಿ 16 ನಂಬರ್ ಸೈಟ್ ಇದೆ. The plaintiff himself admits. So
yes. See, if this admission goes against you. Yes.
Now we will take the depositions of PW3. He claims to be the owner of site number 26.
PW?
3. He claims to be the owner of site number 26. ನಮ್ಗೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು ಅಂದ್ರೆ ಎಲ್ಲ ಅಡ್ಜಸೆಂಟ್ ಓನರ್ಸ್ ದೇ ರಿಲೇಟೆಡ್.
But still you are enjoying the property for so many years.
ಅಕ್ಕಪಕ್ಕ ಗ್ಯಾರಂಟಿ.
PW3 is a lawyer.
Cross examination, page 136. ನಿಶಾನೆ D1 ಸರ್ವೆ ನಂಬರ್ ಮಾಲೀಕರು ಮಾಡಿ ಅದನ್ನು ಅಪ್ರೂವ್ ಆಗಿದೆ ಅಂದರೆ ಲೇಔಟ್ ನಲ್ಲಿ ನಮ್ಮ ಮನೆಯ ಸಾಲಿನಿಂದ 9 ನಿವೇಶನಗಳನ್ನು ಮಾಡಿದ್ದಾರೆ. ಸದರಿ ನಿವೇಶನಗಳ ಎಲ್ಲವೂ ಸಮಾನ ಆಗಿದೆ. ನಮ್ಮ ಮನೆಯ ಸಾಲಿನಲ್ಲಿ 25 ನಿವೇಶನದಿಂದ 33 ನಿವೇಶನಗಳಿವೆ. ಪ್ರತಿವಾದಿಯ ಮನೆಯ ಸಾಲಿನಲ್ಲಿ 9 ನಿವೇಶನಗಳಿವೆ. ಅವು 16ರಿಂದ 24 ಎಂದು ನಂಬರ್ ಆಗಿದೆ. 24 ನಿವೇಶನ ಪಶ್ಚಿಮ ಕಡೆ ಸದರಿ ಮಾಲೀಕರು ಸ್ವಲ್ಪ ಖಾಲಿ ಜಾಗ ಬಿಟ್ಟಿದ್ದಾರೆ. ಅಂದ್ರೆ ಸದರಿ ಖಾಲಿ ಜಾಗ ಪ್ರತಿವಾದಿಯ ಮನೆಯ ಸಾಲಿನಲ್ಲಿ 4 ಮನೆಗಳಿವೆ. ನಮ್ಮ ಮನೆಯ ಸಾಲಿನಲ್ಲಿ 25 ನಿವೇಶನಗಳು ಖಾಲಿ ಇದೆ. ಸಿದ್ಲಿಂಗಯ್ಯನ ಮನೆ ಆದ ಮೇಲೆ ಪೂರ್ವಕ್ಕೆ ಒಂದು ನಿವೇಶನ ಇದೆ. ಅಡ್ಮಿಟ್ಸ್ ದಟ್ ಓನ್ಲಿ 9 sites have been 9 sites ಫಾರ್ಮೇಶನ್ ಆಗಿದೆ ಅಂತ ಒಪ್ಕೊಂತಾರೆ. ದಟ್ ಈಸ್ ಸೈಟ್ ನಂಬರ್ 16 to 24. ಸೊ ಅವ್ರು ಕೇಳ್ತಾ ಇರುವಂತ ಎಕ್ಸಸೈಸ್ ಬಂದಿಲ್ಲ ಅವ್ರ ಅಡ್ಮಿಷನ್ಸ್ ಪ್ರಕಾರ. ಅದಾದ್ಮೇಲೆ ಪೂರ್ವಕ್ಕೆ ಒಂದು ಮನೆ ಇದೆ. ಅದಾದ್ಮೇಲೆ ಖಾಲಿ ಜಾಗ ಇದೆ. ಅದಾದ್ಮೇಲೆ ಒಂದು ಮಾಡಿ ಮನೆ ಕಟ್ಟಿದ್ದಾರೆ. ಅದಾದ್ಮೇಲೆ ಮಧ್ಯದಲ್ಲಿ ಖಾಲಿ ಜಾಗ ಇದೆ. ಮಾಡಿ ಮನೆ.
All right. Forget about all this oral evidence. Now you don't dispute this exhibit C7 ಅಲ್ಲ? This is contrary to exhibit D1.
My submission is that triangular house ಕಟ್ಕೊಂಡಿದ್ದಾರೆ. They would have been enclosed in site number 16. ಅದಾದ್ಮೇಲೆ ಸೈಟ್ ನಂಬರ್ 16 or 17 ಎನ್ಕ್ರೋಚ್ ಆಗಿದೆ. 17, 18 or 19 ಹಂಗೆ ಇಟ್ಸ್ ಅ ಕೇಸ್ ಆಫ್ ಲ್ಯಾಟರಲ್ ಆ ಕಡೆಯಿಂದ ಎನ್ಕ್ರೋಚ್ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ. ಐ ಆಮ್ ಇನ್ ಸೈಟ್ ನಂಬರ್ 24. ನಂದಾದ್ಮೇಲೆ ಅನ್ನಂಬರ್ಡ್ ಸೈಟ್ ಖಾಲಿ ಜಾಗ ಇದೆ. ದಟ್ ಈಸ್ ಬಿಲಾಂಗಿಂಗ್ ಟು ದ DW ವಿಟ್ನೆಸ್ ಹ್ಯಾವ್ ಎಕ್ಸಾಮಿನ್ಡ್. It's not my fault. Actually, site number 22, owner has enclosed on site number 23. Non-sital on 24. That's my submission. Because he himself admits one trikora car of the money and the triangular house Alman. Site number 16 is there. Only 7 feet reduce, I guess, site number 16. It would have been encroached by the landlords will following the drainage of Serenity, municipal Serenity. It's a revenue level.
40 is the 23 to 40 is the.
Yes, sir. 7 feet reduce.
23 to 40 agaithu.
That's what we are. Our own encroach model after drainage formation only it would have been encroached. Site number 16. There would have been encroached by the drainage itself.
No, drainage is next to site number 23. Sorry, site number 16.
Site number 16.
16 also there is one triangular shape. Triangular drainage.
Because it changes. Formation has been taken place in the 1960. The commissioner report was filed in the year 2000.
Yes.
PWC admits there are only 9 sites from the drainage. My site is the 9th site. According to the commissioner report as well as D1.
How many years are
ಪ್ರತಿವಾದಿಯ ಮನೆಯ ಸ್ಥಳದಲ್ಲಿ ಕೂಡ 9 ನಿವೇಶನಗಳಿದ್ದು ಪ್ರತಿವಾದಿಯ ಮನೆಯ ಸಾಲಿನಲ್ಲಿ ಕೂಡ 9 ನಿವೇಶನಗಳಿದ್ದು
ಪ್ರತಿವಾದಿಯ ಮನೆ ಸಾಲಿನಲ್ಲಿ ಕೂಡ 9 ನಿವೇಶನಗಳಿದ್ದು
that is understood. Now, how do you establish that while forming the drainage, one more site measuring 23 into 40 is formed?
This portion we have right side rocket sketch in the my schedule then boundary shown to which I never met. And the commission's report right number 26 is PW house is shown with respect to the mark of the independent.
No, that's not the question. What I'm trying to say is, you are not disputing Exhibit D1. Exhibit D1 shows the drainage, location of drainage. And adjacent to that, there is small triangular shaped site, right? And thereafter, site number 16 starts. Where is the space in the drainage to accommodate one more site measuring 23 into 40?
Thereafter, this land
That is understood. What is the width of Allah? So when you admit Exhibit D1, it is extremely difficult to accept the contention that one more site measuring 23 into 40 is introduced.
I make a specific contention. My case is you don't make a exception. What is the limit of the criteria? In my process, here, make sure that these two are not part of it. Also, admit that in your account, what is less knowledge of that is in the project complete, but
Yes. That evidence is relied upon by the first appellate. This what is the finding of the first appellate court on Exhibit C7?
Because site number 26, which is shown as my northern shower pocket, is shown to be
See, it's like this. Coming into the technicalities of this case, The finding of the first appellate court is based on some evidence. You can't say that evidence, that finding is totally contrary to the evidence on record. This finding of the first appellate court is plausible view because of the evidence led by the parties. Now, how to disturb that in section 100 appeal when you are not to file the cross objection? Assuming that you're not entitled, not filed cross objection, but you are entitled to raise a contention. Still, how do you say that finding is erroneous?
So, my lord, in the trial court, was been observed that I have been put up objection item 20. And he admits in the cross examination itself, exhibit D1 and the commissioner report is admitted. And the plaintiff himself admits in the cross examination that after cycle of 16, triangular house is done. After that, drainage is done. Then, based on the documentary evidence, apart from the oral evidence, documentary, I prove that I have put up construction in the cycle of 24. And there was admissions made by the PW1, PW2, PW3. The effect that there after drainage there is 9 sites which are small. They themselves admit. And according to the court commissioner report and as well as exhibit D1, I have put up construction in the site number 9 sites.
How the finding of the trial court is set aside by the first appellate?
First trial court judgment first out. Then I come to the appellate court.
What are the points for consideration?
Issue number 1. Trial court. Page number 21, my lord, additional issues.
Page number
21. Page number 20 of the paper. The following issues were treated. Whether plaintiff proves that is the absolute owner of the social property. Even we admit that he is the owner of the property. If the plaintiff proves that he is entitled for mandatory injunction as stated in the claim. So the plaintiff proves that he is not entitled for possession of the social property. Then additional issues were framed. Whether defendant proves that he is perfected his title to the social property by way of adverse possession. Then is this court has no pecuniary jurisdiction to try this suit as contained in para 5 of the written statement. Then 1A, whether the plaintiff proves that defendant constructed his house on social property.
Where is the issue that which casts burden on you to say that you have constructed the building on your property? There is no such issue. It is your defense that you have constructed on your property.
Yes. The issue because he has come to the court, the plaintiff has come to the court.
That is understood.
He contends that I have put up construction in his property. The burden was on the plaintiff to prove that I have put up construction in his property. But he himself admits.
How the finding of the trial court is set aside by the first appellate?
Based on the evidences of the PW 1 to 5, the cross examination has not been looked into. Only the chief examinations have been looked.
First appellate court.
Yes.
Read.
Just paragraph number 13.
So what you are trying to say is the first appellate court has not looked into the cross examination of plaintiffs and his witnesses.
And even the commissioner report.
It has not looked into. CW7, C7. No reference.
No. Paragraph number 13 of the trial court judgment, page number 37.
Trial court we will ignore. Come to the first appellate court, where the reference is made to the trial court judgment. So there is no discussion on C7, sir, by first appellate court. There is no discussion.
Paragraph number 14, page number 88. The defendant is examined as PW2. He has specifically stated that there is drainage and distance over the sites around which he considers it and it is 9 side from the eastern end. It is appreciated in the light of the law and it has been not said in the law of the sites in the distance. But it appears that it must have taken into account the triangular and which is referred supra as the first side. Therefore, again, he has been misled and perhaps only then that he has proposed before the court. But we admit that there is a triangular house, but after the triangular house, site number 16. He has also admitted the fact that originally site number 24 was sold to a Nuzan, the original owner. He has to the fact is substantiated from the discussion made above. He has also admitted that the Nuzan sold it in the fact. Therefore, this statement with other corroborates the freedom of fact in favor of the point. As further stated that Mustafa sold it to Sampiraya as a deed. And he had sold it to Chinna Kotaya as per the line. And from Chinna Kotaya purchased it in the 24 and the deed. Therefore, the return statement was not stated that it was second 24 that he had purchased. This fact is admitted in the testimony. What is stated by him in public is also that admitted to the rest of the neighborhood in the vacant space and any thereafter, still of the vacant space, that the siting of the foundation is erected. This indicates that the larger result of the foundation is the conservance of beyond the so this fact is not admitted by either of the.
Just a second. Where is the reference to commission report in the first upload project? Huh? 76. Huh? Yes.
These go against the plaintiff because of the triangular house. There is second 16. Citing this law, the eastern and second 16 is triangular site.
Yes, the first upload group is a finding that next to site number 16 there is a triangular site. That is with reference to exhibit C7. So that first upload code finds that site measuring 23 into 40 as site number 16. No, this is misreading of exhibit C7. No, read it again.
This is the entire paragraph rather than this report. It's not a great report. I don't know if you know what.
It has to be. This one has to be noted. After drainage, site number 16 to 24.
Where?
Page number 75.
After drainage?
Want to show that there is a drainage at the eastern end of the row of sites. And site number 16 to 24 are found in the layout in ascending manner from east to west. Drainage are 16 to 24. Because their pleadings as well. As from east to west, and site number 25 to 23 are found in the ascending order from west to east in 2 rows of 9 sites each. At the western end of there are 2 rows of this side. Site number 24 are located between the 2 rows of this conservancy, which is the northern boundary to the site number 16 to 24, southern boundary to the second 25 to 33. Therefore, it is clear that site number 23 is situated between site number 23 and 24. Site number 26, which is admittedly one of the practice.
Mahesh, Mr. Opponent is not here.
But I'm sorry, Mullah, 2:30 I had a division bench.
All right. No, I could see your back.
4-5 cases for court also, it is very difficult because display is also not properly.
1 minute will change.
Now, what to do now? There are 2006 matters here in this RSA.
Yeah. Yes,
All old matters. Shall I release this matter as parted from parted?
Well, for your lordship information, my lord, senior Shabait, my lord.
Yes.
I used to argue before him 2-3 second appeals in a day. Finally disposed of.
In Dharwad,
yes.
I sat for one session. I decided 6 regular second appeals in afternoon session, one day. Another time, I sat in the morning session, 5 RSS. It all depends upon number of cases, the kind of cases, right?
Point involved also, my lord, is the
point involved also. It all depends. Now, one day here I decided 5 cases, one day, maybe 2 weeks ago. Sometimes it happens, sometimes doesn't. In all these old matters, difficulties, the parties are not instructing the advocates. Advocates are not getting proper instructions.
Lord, the other day I argued on regular second appeal for 2 days. It was heard for 2 days and heard and reserved.
The most of the cases here which I am getting are having 600, 400 pages of paper book. Volumes, yes. What to do?
Madam, I'm ready, sir, but I'm sorry, but I was not able at 2:30.
No, even if you are present, your opponent was not present.
Lord, I have already finished my arguments. It is only the other side took time to make
Yes.
And if they make any representation, if reply is required, I'll do it.
I just wanted to know, should it be referred back to the regular bench?
Your lordship has heard.
All right. List this matter on next Friday.
Yes, please.
None appears to be responding.
May I make one submission? Friday means a lot of split benches should be there. The difficulty.
Wednesday.
Wednesday.
Wednesday. For want of time, list this matter. 41. It will come on Monday. Monday are not here. At the request of for the appellant, list this matter on Tuesday. Sorry? In this matter? No, you have argued this matter. What is the issue? Yes. Let us say, well, they will turn up when the matter is posted for dictating judgment. We'll wait till. It will come on Tuesday.
Madam, 300.